2017, and the supplemental complaint filed by the same complainant, the Honorable Gary Alejano, filed on March 30, 2017, both of which were referred to the Committee on Justice on May 9, 2017. Thus, consistent with the jurisprudence laid down in Francisco versus House of Representatives, which was applied by the 16th Congress in the initiation of the impeachment proceedings against former President Benigno S. Aquino III, which covers two impeachment complaints separately filed on different dates but simultaneously referred to the Committee on Justice on the same day. The Chair hereby declares that the two complaints, both the original and supplemental, filed by Magdalo Party List Congressman Alejano, are deemed initiated on May 9, 2017. This will be the reckoning date for the one-year bar rule on any impeachment case that may be filed against the President under Section 3, Paragraph 5, Article 11 of the Constitution. I was privileged to have been associated along with, of course, the esteemed Majority Leader, Manong Rudy Fariñas, and many others. I think, do we have a list of those who were in the... yes, Congressman Loyola, Congressman Primicias Agabas, Congressman Treñas, Congressman Doy Liachon, Congressman Uaminal, Congressman Arthur Yap, Congressman Kakabagao, Congressman Kit Belmonte, Sato, Romualdo, Gomez, Batocabe, Tugna, Aglipay Villar, Marcoleta, Acop, and many others. I will no longer call on their names, but they were also privileged to have been a part of the impeachment in two of the most controversial and eventful impeachment proceedings in Philippine history, which resulted in the impeachment of former Ombudsman Merceditas Gutierrez that eventually forced her to resign, and the impeachment of former Chief Justice Renato Corona, which led to the conviction and removal of the Chief Justice of the Republic. I would say the impeachment of the late Chief Justice Corona was the most comprehensive impeachment proceeding ever in Philippine history, where I and even Majority Leader Fariñas and even participated as impeachment prosecutors. Of course, together with many of us here in the Committee on Justice of the 16th Congress, I was part of the impeachment case also versus former President Aquino, which was dismissed rather swiftly and uneventfully. Thus, for the benefit of House members who have yet to experience an impeachment proceeding and also of the general public, please allow me to walk you through on the subject Impeachment 101, which covers the congressional power of impeachment. Impeachment is a special process through which a public official may be removed from office. It is a mechanism designed to check abuse of power and is described as the most formidable weapon in the arsenal of democracy. According to Justice Isagano Cruz, impeachment is an extraordinary means of removal exercised by the legislature over a selected number of officials, the purpose being to ensure the highest care in their indictment and conviction and the imposition of special penalties in case of finding of guilt, taking into account the degree or nature of the offense committed and the high status of the wrongdoers. Father Joaquin Bernas, a distinguished member of the Constitutional Convention and a preeminent authority in Philippine constitutional law, described the process of impeachment as a political process. And for that particular reason, the responsibility for it has not been given to a court characterized by cold neutrality, but rather to a political body. In summary, impeachment is a special political process of holding accountable the highest public officials in the land, and it is a power exclusively lodged in Congress by the Constitution, to the exclusion of all other bodies, I must say. Let me give you a brief history on the impeachment in the Philippines. Under the 1935 Constitution, the very first impeachment complaint was against a Philippine president, which was filed in 1941 against President Elpidio Quirino. This was followed by an impeachment complaint against President Diosdado Macapagal in 1964. Both complaints were dismissed by the House of Representatives. Under the 1973 Constitution, the provisions for impeachment were rewarded. The grounds of graft and corruption were added to the existing grounds for impeachment, which are culpable violation of the Constitution, treason, bribery, and other high crimes. It also included the members of the Constitutional Commission to the list of impeachable officers. Finally, it granted to the National Assembly the exclusive power to initiate, try, and decide all cases of impeachment. Upon the filing of the verified complaint, the National Assembly may initiate impeachment by a vote of at least 1/5 of all its members. The only impeachment complaint under the 73 Constitution was filed by 56 lawmakers against President Ferdinand Marcos on August 13, 1985. The impeachment complaint was dismissed by the National Assembly the next day due to unsubstantiated allegations in the complaint. The present provisions for impeachment are found in Article 11 of the 87 Constitution, and it added the ground of betrayal of public trust to the list of grounds for impeachment as found in the 73 Constitution. It also included the Ombudsman as one of the impeachable officers, in addition to the President, the Vice President, the members of the Supreme Court, and the members of the Constitutional Commission. The first impeachment complaint under the 87 Constitution was filed against President Corazon Aquino in 88 on the grounds of graft and corruption. This complaint was dismissed by the House of Representatives. Thereafter, several impeachment complaints were filed against President and Vice President of the Philippines, members of the Supreme Court, Ombudsman, and members of COMELEC. However, only 3 impeachment complaints had been endorsed by the House of Representatives to Senate for trial. The first is that involving President Joseph Ejercito Estrada in year 2000. 77 members of the House of Representatives, or more than 1/3 of the 218 members of the House then, endorsed the resolution of impeachment against President Estrada. I think Majority Leader was also in that Congress, and many others, including the Speaker. 11 Congress, and
member of the 11th Congress.
thus the articles of impeachment,
Even the President of the Philippines.
and even the President, the incumbent President. Thus, the articles of impeachment were immediately transmitted to the Senate, and the impeachment trial began. However, before the trial could have concluded, President Estrada vacated Malacanang, and then Vice President Gloria Macapagal Arroyo was sworn in as President. The next successful impeachment at the House of Representatives was against Ombudsman Gutierrez. 2 impeachment complaints were simultaneously referred to the Committee on Justice on August 22, 2010. Both complaints were considered by the committee, and upon a majority vote of all members of the committee, were deemed sufficient in form and substance. On March 1, 2011, the committee found sufficient grounds for impeachment, and on March 8, 2011, the committee found probable cause to impeach Ombudsman Gutierrez. Finally, on March 21, 2011, With a vote of 210 members in favor, the House endorsed the resolution setting forth the articles of impeachment against Ombudsman Gutierrez. However, before the Senate could begin its trial, Ombudsman Gutierrez resigned from her post on April 29, 2011. The very first impeachable officer to have been successfully impeached by the House of Representatives and convicted by the Senate was the late Chief Justice Corona. Similar to the impeachment of President Estrada, more than one-third of the members of the House, or 188 out of 285 members, endorsed the articles of impeachment against Chief Justice Corona. Trial in the Senate ensued, and on May 29, 2012, 20 senators voted for a guilty verdict against 3 voting not guilty. Thus, Chief Justice Corona was convicted of the charge against him for betrayal of public trust and culpable violation of the Constitution. Former President and now Pampanga Representative Gloria Macapagal-Arroyo had been subjected to 4 impeachment proceedings in 2005, 2006, 2007, and 2008, all of which were dismissed by the Committee on Justice. The most recent impeachment proceeding was in 2014 during the 16th Congress, where 3 verified impeachment complaints were filed against former President Benigno Aquino on July 21, July 22, and July 24, respectively. The 3 complaints were simultaneously referred to the committee on August 11, 2014, and were considered by the committee separately. Upon due consideration, the members of the Committee on Justice declared all complaints sufficient in form but insufficient in substance. The committee then submitted its report to the plenary together with a resolution recommending the dismissal of the 3 impeachment complaints. However, the 16th Congress adjourned without acting on the report and the resolution of the committee. So now let us proceed to the impeachment, the power of impeachment under the 87 Constitution. The impeachment power of Congress is found in sections 2 and 3 of Article 11 of 1987 Constitution. Section 2 enumerates the official who can be impeached and the grounds on which they can be removed by impeachment. Only the President and Vice President and the members of the Supreme Court and members of the Constitutional Commission and the Ombudsman may be removed from office on impeachment for and conviction of 1. Culpable violation of the Constitution, 2. Treason, 3. Bribery, 4. Graft and corruption and other high crimes, or betrayal of public trust. This list is exclusive. No other public official may be removed by impeachment, and no other grounds can be alleged other than those that was just mentioned. The next section, Section 3, outlines the procedure to be followed in impeachment proceedings. The first paragraph of Section 3 states that the House of Representatives shall have the exclusive power to initiate all cases of impeachment. Please take note of the phrase exclusive power to initiate all cases of impeachment. This means that no other person, court, or tribunal can initiate the impeachment of a public official. The second paragraph of Section 3 describes the 3 modes of impeachment. This mode is by a verified complaint filed by any member of the House of Representatives, which is the mode chosen by Representative Alejano when he filed this complaint last March 16 and supplemented it last March 30, 2017. The second mode of impeachment is via a verified complaint by any citizen upon a resolution of endorsement by any member of the House of Representatives, which was done during the 2005 to 2008 impeachments, complaints of former President Gloria Macapagal-Arroyo. the 2010 impeachment of Ombudsman Gutierrez, and the 2014 impeachment of President Aquino. Finally, the third mode of impeachment is a verified complaint or resolution of impeachment filed by at least one-third of all the members of the House of Representatives, which was the mode used in the impeachment of former President Estrada and of former Chief Justice Corona in 2012. Section 3, on the other hand, also describes the procedure for initiation of impeachment complaints. Under the first two modes of impeachment, the impeachment proceedings are deemed initiated upon the filing of the verified complaint and its subsequent referral to the Committee on Justice. This is the ruling of the Supreme Court in Francisco versus House of Representatives, which is the prevailing jurisprudence on the matter. As in this case, the verified impeachment complaint filed by Congressman Alejano was filed before the SecGen on March 16, 2017, followed by a supplemental complaint also on March 30, and they were both referred to May 9, 2017, and thus, as I mentioned earlier, the same is already hereby initiated. Applicability of rules of procedure in impeachment proceedings. I'd like to tackle this so that this will guide all our members. With the impeachment proceeding having been initiated, the applicable rules that would govern our proceedings are the rules of procedure in impeachment proceedings of the House of Representatives. These rules were adopted by the House on August 23, 2016, and were published on August 26, 2016, in the Manila Bulletin and the Philippine Star. Under Section 4 of the rules, upon due referral, the Committee on Justice shall determine whether the complaint is sufficient in form and substance. With regard to the determination of sufficiency in form and substance, we shall be guided by the precedents set by the Committee of previous impeachment proceedings. On the subject of form, the committee has consistently been liberal in favor of the complainants in determining sufficiency of form of the verified impeachment complaints. The only requirements with respect to form as found in our Constitution are: 1. In case of complaints filed by any member of the House, the complaint must be verified. 2. In case the verified complaints filed by any citizen, the verified complaint must be endorsed through a resolution, which is not the case in this particular proceeding. In all cases, the verified complaint must not fall under the one-year bar rule. In other words, the verified complaint must not have been filed within 1 year from the last impeachment proceedings initiated before the committee. With respect to filing of supplemental complaints, the committee had previously rejected the filing of a supplemental complaint before the committee during the 2007 impeachment of former now Congressman GMA. However, take note that in that case, the complaint directly filed the supplemental complaint and addendum to the complaint directly with the committee and not before the Secretary General as required under the rules. In this case, the supplemental complaint was filed before the SecGen, and therefore we have, as I said, ruled that this also is covered by these impeachment proceedings. In similar fashion, multiple impeachment complaints had been simultaneously referred to the committee before. In 2010, 2 impeachment complaints against Ombudsman Gutierrez were filed on different dates, but both complaints were simultaneously referred to the committee. Ruling on the propriety of such referral, the Committee on Justice ruled that although there were 2 different complaints filed, there was only 1 single impeachment proceeding initiated then by both complaints, when both complaints were simultaneously referred to the Committee on Justice. This ruling was even upheld by the Supreme Court in the case of Merceditas Gutierrez versus House of Representatives, where the court stated that the filing of an impeachment complaint is like the lighting of a matchstick. Lighting the matchstick alone, however, cannot light up the candle unless the lighted matchstick reaches or torches the candle's wick, and so on and so forth. Similarly, in 2014, 3 impeachment complaints against President Aquino were simultaneously referred to the committee. The committee then took cognizance of the said complaints, and a single impeachment proceeding was deemed initiated. Again, we shall be guided by these rulings when we determine sufficiency in form of the verified complaint and supplemental complaint, which were simultaneously referred to the committee on May 9, 2017. After the determination of sufficiency of form, and assuming that the committee finds an impeachment complaint sufficient in form, the next step under the rules on impeachment is the determination of sufficiency in substance. Section 4 of the Rules of Procedure in Impeachment Proceedings state that the requirement of substance is met if there is a recital of facts constituting the offense charged and determinative of the jurisdiction of the committee. Following established precedents, the Committee on Justice has consistently followed the standard of individual appreciation by each member of the committee in determining whether a verified impeachment complaint is sufficient in substance. After proper manifestations and debates among the members of the committee shall vote on the sufficiency in substance of the verified impeachment complaints. This is where the political nature of impeachment proceedings come in play. The individual vote of each member represents the vote of his or her constituents on whether or not the impeachment proceeding should proceed to the next step, which shall now require the respondent to file an answer under oath and to submit affidavits, evidence, and other memoranda before the committee. The question of whether or not there is a need to subject the respondent to further steps in the impeachment proceeding is subject, and I repeat, subject to the individual appreciation of each and every member of the committee on the sufficiency in substance of the verified complaint, and we shall vote upon this, and all votes shall count. Once the committee determines the verified complaint sufficient both in form and substance, the next step is the determination of sufficiency of the grounds alleged in the complaint. This would require, under Section 6 and 7 of the Rules on Impeachment, the submission by the respondent of an answer under oath, affidavits and counter-affidavits, evidence and other memoranda before the committee. Should the committee find sufficient grounds for impeachment, the committee shall thereafter determine whether probable cause exists on the basis of the evidence submitted to the committee. Similar to the finding of sufficiency in substance, the determination of sufficiency of the grounds and the existence of probable cause for impeachment is left to the individual discretion of the members. This is due to the inherent political nature of impeachment, as earlier mentioned. Thereafter, once the committee has determined the existence of probable cause, or if the committee dismisses the complaint for insufficiency in any of the stages mentioned above, the committee shall then file its committee report together with its corresponding resolution setting forth the articles of impeachment or its resolution dismissing the complaint. This is the end of the impeachment proceeding before the committee, and the House in plenary session shall vote whether or not to approve the resolution endorsing the articles of impeachment, to approve the resolution dismissing the complaint, or to override a resolution dismissing the complaint by a vote of 1/3 of all members of the House of Representatives. For today's impeachment proceedings, we will be hearing the the original and supplemental impeachment complaints filed by Congressman Alejano. Let me just give you in a nutshell what this impeachment complaint is all about. Congressman Alejano alleged that President Duterte should be impeached because he committed the following acts: culpable violation of the Constitution, bribery, betrayal of public trust, graft and corruption, and other high crimes. For the first charge, complainant alleged President Duterte betrayed public trust, committed bribery, and culpably violated the Constitution, and committed high crimes by adopting a state policy inducing policemen, other law enforcement officers, and or members of vigilante groups into extrajudicial killings without trial and due process, pursuant to the current administration's war on drugs and Oplan Tokhang. He contended that the President acted as a virtual cheerleader for the summer killing of drug and criminal suspects. Furthermore, the complainant alleged that President Duterte committed high crimes of multiple murder. Second, complainant alleges that President Duterte should be impeached for backing and or supporting the killing of crime suspects, political and personal enemies, and innocent individuals through the Davao Death Squad, even prior to his presidency. Thirdly, complainant alleges that President Duterte committed graft and corruption based on questionable hiring of 11,000 contractual workers when he was then the mayor of Davao City, for failing to report in his latest statement of assets, liabilities, and network numerous secret bank accounts as well as properties that he and his child, Veronica Duterte, reportedly owns. President Duterte's unexplained wealth and unreported properties, and for gross disproportion between the legitimate means of income of President Duterte and his family and the reported wealth. In his supplemental complaint, Congressman Alejano alleged that President Duterte should be impeached for the following reasons: for failing and or refusing to assert and reiterate the exclusive sovereign rights of the Philippines over the Benham rice during the incursions of Chinese survey vessels in the area, despite a contrary ruling of the UN Commission on the limits of the continental shelf, that said area is part of the extended continental shelf of the Philippines. And two, for failing and or refusing to protest and raise issue over the plan of China to construct an environmental monitoring station at the Panatag Shoal or Scarborough Shoal. So my dear colleagues, at this point, let us be reminded that there are two constitutional principles at play in our proceedings today. Our Constitution states that public office is a public trust. This provision reminds us that there is no vested right in public office and all powers emanate from the people. The wisdom of this provision is to safeguard the public from malpractices and abuse of power of our erring officials, and to provide the basis for legal recourse on punishing and retribution for such offenses. This brings us to the constitutional remedy of impeachment. Let us be reminded that the impeachment is an extraordinary mechanism to oust the most powerful officials of the land, if need be, for offenses and abuses committed. Impeachment is an extraordinary remedy, for it only provides very specific grounds against very specific persons, couched on very stringent and detailed procedure. In resolving the present impeachment complaint, let us be mindful that this is a case filed less than a year before the President's assumption into office, that the complaint is filed during a crucial period when necessary legislative reforms are being put in place, measures that are vital to the re-engineering of the criminal justice system. Be that as it may, let the mandate of the Constitution govern. Under the Constitution, this committee is duty-bound to conduct this impeachment proceeding with all diligence, fairness, and justice. We have a crucial task ahead of us today. We owe to the people to resolve this with dispatch, this impeachment case, so the people will uphold the highest respect to the highest office of the land at all times, and also to give the President the full trust and confidence to faithfully perform the duties and responsibilities of his office without fear or favor. Thank you, and good morning, everyone.
Mr. Chairman.
So at this juncture, we will now, you want to say something?
Yes, Mr. Chairman.
Congressman Lagman.
Just a short statement. Well, thank you very much for that very thorough and lengthy exposition on the nature and history of impeachment proceedings in the Philippines. But let me add some points to give a proper anchorage and orientation to impeachment proceedings. While it is correct that an impeachment proceeding is a political exercise or process, it is, however, impressed with a judicial character. This is the reason why we have a verified complaint, a complainant, a respondent, determination of sufficiency in form and substance, and, if necessary, determination of probable cause to impeach the respondent who is given the opportunity to file a verified answer. And the respective parties are also given the opportunity to adduce their evidence, both testimonial and documentary. In the impeachment trial, select members of the House act as prosecutors, and the Senate sits as a court where senators are senator judges. That is the judicial character of the impeachment proceedings. It is also because of the judicial nature of impeachment proceedings that the Constitution mandates that the proper committee, or in this case, the Committee on Justice, must conduct a hearing. Section 32, paragraph 2, Section 3, paragraph 2 of Article 11 of the Constitution on the accountability of public officers unequivocally provides, and I quote, "The committee, after hearing," let me underscore that, after hearing, and by a majority vote of all its members, shall submit its report to the House within 60 working days from such referral, together with the corresponding resolution, unquote. In other words, no report can be submitted to the plenary on the dismissal or upholding of a complaint without prior hearing. Without prior hearing. The hearing envisioned by the Constitution partakes of two phases. First, a preliminary hearing on the sufficiency of form and substance of the complaint, and second, a full-blown hearing to determine the absence or existence of probable cause to impeach the respondent after finding that the complaint is sufficient in form and substance. Accordingly, I beseech the honorable members of the Committee on Justice to afford the complainant, the Honorable Gary Alejano, the opportunity to be heard and the chance to adduce his arguments on why his complaint for impeachment is sufficient in form and in substance. And as far as substance is concerned, why it satisfies the minimum standard provided by the House rules on impeachment, that, quote, requirement of substance is met if there is a recital of facts constituting the offense charged and determinative of the jurisdiction of the committee. Again, while it is true that an impeachment proceeding is a political exercise, it is not a partisan enterprise. A political process entails an exercise of values, advocacies, and judiciousness. Partisanship is the direct opposite. It is the blind adherence to the dictates of a party or an aggregation. It is an injudicious allegiance to a figure or a group. Mr. Chairman, Representative Gary Alejano deserves to be heard, and the Committee on Justice, as well as the Philippine public, are entitled to hear the complainant in the instant impeachment proceedings. Thank you, Mr. Chairman.
Thank you,
Mr. Chairman,
Congressman,
point of order.
Lagman.
Point of order. Mr. Chairman,
What is the point of order?
I invoke Rule 5, Section 14.
And-
Earlier, my objection is this committee, before proceeding to form and substance, must rule on the nature of the supplemental complaint. I heard the opening statement of the good chairman that the legal basis for considering the original and supplemental complaint as being initiated at the same time as being the case of Francisco. Francisco, Mr. Chairman, was decided in 2003. I was counsel in the 2007 complaint where we filed the supplemental complaint. And it was the good gentleman from Albay, Congressman Lagman, who characterized that supplemental complaint as a prejudicial question before we can hear the issue of form and substance. Since it was then the position of Congressman Lagman in the 14th Congress that a supplemental complaint is deemed barred by reason of the Constitution and what appears now as Rule 5, Section 14 of our rules. So if the legal basis is Francisco, certainly our position then as complainants was the supplemental complaint should have been heard by the committee. But Congressman Lagman prevailed then, arguing that there was a need to resolve prejudicial question, and the committee resolved that issue as the supplemental complaint being barred. This after the ruling in Francisco, which we also invoked. And that is why I think at this juncture, Mr. Chairman, it is important to bring as a point of order the issue of supplemental complaint. I understand there is a later case decided by the Supreme Court. But in political questions, where the Constitution has a textual commitment to a specific branch of government and the House has exclusive prerogative to initiate complaints, we have had precedents where this House, in order to defend its independence, has ignored rulings of the Supreme Court. And I can cite those, but I don't need to do so. And that is why I bring now, as a point of order, the issue of the supplemental complaint, and I submit that pursuant to the practice adopted in the 14th Congress by no less than Congressman Edsel C. Lagman, that we should declare the supplemental complaint as a second impeachment complaint and therefore barred before we proceed with the discussion on sufficiency of form and substance on the original impeachment complaint. And I invoke for this purpose the textual provision of the Constitution and the practice of this House, led by this committee, led then, or I think it was a subcommittee that Congressman Lagman then led, no? And their decision by way of practice and tradition that supplemental petitions should be barred as second complaints. Thank you, Mr. Chair.
Thank you for that manifestation, Congressman Roque. The chair will rule on that. It has you already mentioned that the rule as now covered by the present rules that was adopted in 2016, published in 2016, already has covered this. So your point of order has been overtaken by events. Now we have a rule to follow, and that rule is enshrined even in the rules of the rules on impeachment. So the same no longer will hold water.
Mr. Chairman. But insofar as I invoke a specific rule, Rule 5, Section 14, I do not see any rule in our rules for impeachment that would be applicable to supplemental complaints. There is none, Mr. Chairman, and that is why I'm bringing this as an issue.
Mr. Chair.
Mr. Chairman.
The ruling is covered by the decision itself, the jurisprudence now laid down in the Francisco case, which considers as having been initiated the impeachment case which is filed and referred to the committee. So if these two requirements concur, then that should be the basis for initiation of the impeachment complaint and the start of the proceeding.
I will not belabor the point, Mr. Chair, because of the urgency of the matter. I would like to manifest that unlike 2007, when Congressman Lagman barred our supplemental complaint as a prohibited complaint, I think Congressman Alejano is far luckier that the 17th Congress will hear his allegations in his supplemental complaint.
As pointed out by the chair, we will dispose of this impeachment proceeding in a just and fair manner, but taking into consideration the need to dispose of this with dispatch so that we will not derail the other important mandates of the Committee on Justice. Vice Chair Liachon?
Yes, well, with deference to Congressman Roque, while it is there was a subsequent event in 2014, more or less in his interpretation would be an overturning of the 2004 decision of Francisco. It is with all due respect that I concur with the chairman that there is a standing jurisprudence on the matter, and that is decided by the Supreme Court. Well, if there was subsequent event during the time of the hearing of a certain complaint with Congressman Edsa Lagman, I think that was not brought to the Supreme Court, so we should respect that still, as of now, the standing jurisprudence on the matter are those matters initiated by no less than the Supreme Court. And then, with all due respect, Mr. Chairman, I think I would like to agree with the chair that the two complaints should be disposed simultaneously in order to have a full-blown hearing on the matter with respect to the charges filed by Congressman Alejano. Thank you, Mr. Chair.
Chairman.
Thank you, Vice
Mr. Chairman.
Chair. Before Deputy Speaker Castro, we recognize the minority leader who who wished to be acknowledged first.
Thank you, Mr. Chairman. Good morning, Your Honors. We're facing here with voluminous papers, impeachment complaint, different rationalization that procedures are not proper. Before I excuse myself, I just would like to air the position of this representation. We are impeaching a president with a 80.3% rating SWS survey, acceptance and popularity. Ang ibig sabihin nito, mga kasama, sa bawat 10 nakakasalubong mo, 8 ang nagsasabi gusto nila si President Duterte. At the end of the day, ang gagawin natin ito will be to satisfy people because the citizens is waiting for the outcome of this. But what I'm saying is, I am in my end of my political career. Malapit na ho yung twilight ko. And I've never seen a president. Sabagay, wala pa siyang 1 year, who is not interested in enriching himself. And that is one quality that we need. An honest president that this committee would like to impeach because of the proceedings. As I've said, at the end of the day, my honest opinion is this impeachment will not fly. So I just have to voice my personal position on this. Thank you, Mr. Chair.
Thank you,
Chairman.
Minority Leader. You have just witnessed the non-partisan character of the 17th Congress. So we now recognize Deputy Speaker Castro.
Thank you, Mr. Chairman. I think, Mr. Chairman, there is no conflict between the position taken by Congressman Roque as well as the position taken by Congressman Liachon. This representation took note of the statement of Congressman Liachon that anything that subsequently accrues after the filing of the complaint may be subject of a supplemental complaint. But going over the allegations of the supplemental complaint filed in the present complaint by Congressman Alejano, it shows that the causes of action are based on causes that were already existing at the time of the filing of the complaint. And therefore, even on the basis of the provision of the rules of court that is suppletory in character in this proceeding, that supplemental complaint is now barred by the rules under Rule 5 and the provision of the rules of court.
Thank you for that. We will hold in abeyance ruling on this when we go into the form of the complaints. But for the last manifestation on this matter, I recognize Congressman Lagman.
Mr. Chairman, I recall that I invoke the prejudicial question in an earlier impeachment case against the former President Gloria Macapagal Arroyo. Not in that particular instance cited by the Honorable Roque. But I will discuss this with him after the hearing to just impress on him that he was referring to another impeachment proceedings. But wherein the factual and legal settings were different. Now, with respect to the statement of the Honorable Danilo Suarez, let me just reiterate what the Honorable Chairman said, that there is no vested right to a public office. In other words, no amount of popularity poll, no amount of popular vote will immune an errant high public official from impeachment proceedings, which is the sole jurisdiction of the House of Representatives through the Committee on Justice.
Mr. Chair.
Thank you. Just to provide closure on this particular point, let me just read, I skipped this in my opening remarks, but the case of Merceditas Gutierrez versus House of Representatives would guide us on this particular point, and I quote, "The filing of an impeachment complaint is like the lighting of a matchstick." Lighting of the matchstick. Lighting the matchstick alone, however, cannot light up the candle unless the lighted matchstick reaches or torches the candlestick. Referring the complaint to the proper committee ignites the impeachment proceeding. With a simultaneous referral of multiple complaints, whether different or supplemental, filed, more than one lighted matchsticks light the candle at the same time. What is important is that there should only be one candle that is kindled in a year, such that once the candle starts burning, subsequent matchsticks can no longer rekindle the candle. So I guess that should, in a nutshell, cover whatever arguments there are on the matter, noting that this is a jurisprudence laid in the Merceditas Gutierrez case. So thank you for that. And now we will now consider initial consideration of the verified complaint for impeachment of President Rodrigo Duterte filed by Honorable Gary Alejano. In this particular case, we have distributed all of the copies, and as pointed out earlier, there are only things that we should consider when we look at the form, and that is the verified complaint filed by, which in this case, which in this case is filed by a member of the House of Representatives. And that said, we don't have to argue on this particular point, except that the chair will now be open to, because you have already reviewed this, given that we had distributed this 5 days ago, we presume that you have already read these impeachment complaints and looked at the form on the matter. And so at this juncture, I would recognize the Honorable Majority Leader
Yes, Mr.
on the point that he would want to emphasize on the matter of form of this impeachment complaint.
Thank you, Mr. Chairman. Good morning, colleagues. Our first task is to determine sufficiency in form. And looking at the complaint, there is a verification. I'd just like to make some clarifications to the complainant, because this is a unique case. A complainant can be made by, a complainant can be any citizen of the Philippines, and then a member must endorse it. But in this case, it is a representative himself who is the complainant. So he had to issue a verification for that purpose, because it should be the complainant who should verify his complaint. So since the representative is here, are you affirming your verification, Congressman Alejano, 4 paragraphs? Do you affirm the verification that you made?
You want to read it for the record?
Especially on number 3 of your verification, which you made under oath twice. Once before a notary public and second before the Secretary General. Number 3 states, we hereby confirm and affirm that the material allegations made therein, meaning to this complaint, are true and correct of our own personal knowledge and as culled from authentic records. Do you affirm this?
Yes, Mr. Chair.
Okay.
Mr. Chair, before we proceed with the determination of sufficiency, inefficiency of the impeachment complaint as to the form, may I request, Mr. Chair, that may I be allowed to have my opening statement or sponsorship of the impeachment complaint? Because I will answer the specific questions of the majority for leader.
No, Mr. Chairman, I have the floor. We do not have opening statements of complainants here. There is a pending complaint here. The committee will dispose of the complaint. You will answer questions made by the committee or its members. A complainant cannot make an opening statement here. We are now determining sufficiency on form, so let me proceed. Now, Mr. Chairman,
Mr. Chair.
I will ask the complainant.
The Majority Leader has the floor.
First, in charge number 1, the complainant states under oath that in just over 8 months since he assumed office last June 30, 2016, more than 8,000 individuals, more or less, have been killed in respondent Duterte's war on drugs. And the PNP's Oplan Tokhang and Oplan Double Barrel, particularly in police operations, as well as in vigilante and gangland style of assassinations and or executions or salvagings, most of which have gone uninvestigated by the authorities. Now, I will ask the complainant, do you have personal knowledge of 8,000 more or less killings committed in this campaign?
Mr. Chair, I insist that I will be given the opportunity to make a statement because, Mr. Chairman, I will go over it. I will be able to cover these questions if I will be given the chance to make a statement. Because for fairness, Mr. Chair, this is an important issue why I should not be allowed to make a statement.
You
We will go through it.
you will make a statement at the proper time. We are still on the form. We have not even considered the entire complaint itself. That will happen later when we go to the substance. So these are questions being posed upon you as the complainant, because you did the verification, you swore to the truth of these material matters based on your own personal knowledge. So before we even go to that
Chair.
point that you would make your remarks, I will give you that time when we go to sufficiency in substance.
Mr. Chair, kaya nga po sinasabi ko ho na di ba ho at the start, maklaro ko ho yung aking tayo, yung aking statement sa issue na ito before we go to the details. Because I will answer, yes, Mr. Chair, I will answer the question.
Then please do answer, kasi pointed questions to para mas mabilis nating ma-resolve itong mga issues na to, because we are only dealing on the form. And there is in the rule that the complaint must be verified and you as a complainant complied with that. But before we can even go to the specific allegations, yun ang tinatanong kung meron ka bang personal knowledge. Yun lang naman yung tinatanong. Kanya please let us proceed by requiring you to answer the queries of the majority leader.
Point of order, Mr. Chairman. Point of order, please. Here. De Vera, yes.
Sige.
Your Honor,
What is the point of order?
Since the point of order, Your Honor, since the majority leader is asking for personal knowledge, maybe the committee be informed or enlightened. What is the meaning of personal knowledge, Mr. Chairman? Your Honor, please.
Well, personal, is he asking the...
Your Honor, for the guidance of Congressman Alejano, so that in asking, it's not because I'm belittling him, but the legal meaning of personal knowledge, Your Honor.
Anyway, unang-una, when you raise a point of order, you must point out the rule that is being violated. Now you're asking for a clarification rather than a point of order. And if only to accommodate you, would you wish to answer that, Majority?
No more. I am asking the complainant to affirm his verification. So may I proceed? Since he stated under oath that the material allegations, and this is the first allegation he made, that the President is responsible for the killing of more than 8,000 people. So I'm asking him, as he has already stated under oath twice, that these material allegations are true and correct of his own personal knowledge. So I'm asking, is it correct and true that he has personal knowledge of at least, more or less, 8,000 killings?
Mr. Chair, I will answer that question, but I would like to, I would have wanted to ask this. I've been raising kanina pa ho. I would like to inquire sana how we go about the hearing, because we know that there are different stages, the form, substance, and then determination of the probable cause. I would have wanted to clarify the sequence and clarification whether I will be given the statement. But nonetheless, yung statement ko sana ay magsasagot din po sa tanong ni Majority
Please, Mr. Chairman, may I ask that the complainant answer a very simple question? He
Sasagutin
stated
ko po.
under oath, so does he have personal knowledge of at least, to quote his own averment, more than 8,000 individuals, more or less, have been killed in respondent Duterte's war on drugs?
May I be allowed to read my answer to the majority for
Point of order, Mr. Speaker.
Read your answer
Yes.
only on that point that was being asked, not of any remarks that you averted to earlier. So just on that point, do you have
I will answer,
personal
Mr.
knowledge
Chair.
of that, just on that point?
May I be allowed to read my answer to the question to the majority for
Just on that point,
Yes.
If it will respond to the question,
Yes.
Mr.
Yes.
Chairman.
It will
Okay,
respond.
thank you.
So, Mr. Chair, on the issue of the truthfulness of the verification included in the complaint, mayroon pong question nga na si Majority Floor Leader sa verification na kaakibat ng aking impeachment complaint kung saan sinabi ko I am attesting to the truth of the facts alleged in my impeachment complaint of my own personal knowledge as culled from authentic records. Unang-una po, halos lahat ng nakasaad sa aking impeachment complaint ay galing po sa open sources. Particular na sa mga policy statements, public speeches, and media pronouncements ni President Duterte mismo. Tayo pong lahat mismo ay narinig ang mga talumpati at pahayag sa media ng Pangulo kung saan inutusan niya ang ating
Mr.
mga...
Chairman, may I ask to answer the question because he's now talking of
Mr.
newspaper accounts. Do you have personal knowledge of 8,000 killings? That's the question. Very simple. Yes or no?
The personal knowledge na ako po mismo nakakita sa pinatay, hindi po.
Okay, so the answer is no.
Kaya nga po,
Okay.
Mr. Chair,
Let me
I would
proceed.
have answered the
Let me
question of
proceed,
Majority Floor Leader.
Chairman.
Okay.
And then, again, it states here that when, second paragraph, following that, Rodrigo Duterte is reported to be responsible for the murder and deaths of at least 1,424 individuals in Davao City from 1998 to 2015 to the entire country. Do you have personal knowledge of these allegations of deaths being committed by the Davao Death Squad? I ask the complainant, Mr. Chairman.
Mr. Chairman.
Before that, can you please answer that? There is a pending question.
Mr. Chair, I wanted to answer the question. I was not allowed to read my answer because nandito po yung sagot. I understand there's a question. I will answer that because you're asking me personal knowledge of a witness. What I stated here, personal knowledge of a complainant and an endorser. So I would like to answer that, Mr. Chair.
Mr. Chairman,
Alam mo,
my question
this
is simple.
ika-clarify ko lang, Gary, this is an impeachment complaint. And if you will take, I don't know if you ever had been involved in a case pending before the investigating prosecutor, parang preliminary investigation. We are like the prosecutors here conducting preliminary investigation, and you have a complaint. And so yun yung sinasabi ni majority na in a proceeding before the investigating prosecutor, wala mga opening remarks doon. Yung opening remarks sa chair yon, because I am opening a impeachment proceeding. The rest, yun na initial consideration of a verified complaint, we are now focused on the complaint and in particular on your allegations in the complaint. And malinaw yon for lawyers, siguro I will ask Harry Roque kung ano yung clear understanding of what personal knowledge is versus hearsay. Yung hearsay, yung narinig mo o nabasa mo sa dyaryo o naikwento sa'yo, that is hearsay evidence and that will not stand trial. Kanya kung ikwekwento mo sa amin na yan ay narinig mo, etc., hindi po yun ang tinatanong ni majority. Ang tinatanong niya, personal knowledge, meaning
Mr. Chair.
Under Rule 130, Section 36, Rules on Evidence, personal knowledge is that which are derived from one's own perception. So hindi pwede dito yung perception ng others na inadapt mo and that is your personal knowledge. That cannot be. So kung sasagutin mo kami ng pagkahaba-haba na ang sasabihin mo, lahat sila, you can directly answer it by yes or no if you have your if you can derive it from your own perception. And that is what the rules on evidence, which is suppletorily applied in this impeachment proceeding for purposes of deliberating on your complaint. So, sana malinaw sa iyon para we will not go the rounds and you insisting na you want your personal remarks, yung opening remarks, and then hindi mo naman nasasagot directly. Kasi ang ginagawa ni majority dito, point by point tinatanong niya para mas malinaw tayo, and we will deal on the 5 points that you have raised as grounds for impeaching the President.
Mr. Chair, gusto ko pong sumagot. I am just being cut when I'm answering, Mr. Chair. Sabi po natin, importante po itong issue na ito, sasagutin ko ho. But the point is, I was not given the chance to answer. So may I be allowed to
Sige, ganito ang gawin natin, ano? There is a pointed question. The question is answerable by yes or no based on your own perception. You say your answer and then you explain. Siguro that will be fair. Pero kung babasahan mo kami ng remarks mo, palagay ko, maliligaw tayo, hahaba tayo. And please bear with us kasi we have a lot of other things to do in the committee.
Mr. Chairman, may I just clarify from where I'm coming from? Kasi po, as you all know, I am the chairman of the Committee on Rules of the House of Representatives. Ang function po ng Committee on Rules, which I chair, is, ang jurisdiction po ng Committee on Rules, all matters relating to the rules of the House, rules of procedure governing inquiries in aid of legislation, rules of procedure in impeachment proceedings, order of business, calendar of business, the referral of bills. In fact, your complaint, Your Honor, came to my committee, and it was my committee that included it in the calendar of business and was referred to the Committee on Justice because that is how our rules are crafted. So here, we have a complainant kasi po, para rin po ito sa education of other members. If you have a complaint against an impeachable officer and your information are not your own, of your own personal knowledge, let that person be the complainant and then you will endorse. Para yung complainant po na yan, mapapanumpaan niya yung kanyang sinasabi. Kasi po, in a long line of cases, ito po ang purpose ng verification para maintindihan po ninyo. In the case of Lucy Torres versus Codilla, decided in March 20, 2012, GR number 195191, the purpose of verification is to secure an assurance from the complainant that the allegations in the pleadings are true and correct, not merely speculative or hearsay. So kailangan nga po, pinapanumpaan po ninyo yan, alam, very clear naman po sa English ito that they are the material allegations made herein. Kasi nga po, kung hearsay naman, isasayangin mo yung panahon namin dito. You will be wasting our time here because how can we bring this forward if all your information are hearsay? And so, let me proceed, Mr. Chairman. In fact, you cooperate with me because I may even move that we will still find sufficiency in your form, but bear with me and I will ask because these are your material allegations which you stated under oath are true and correct of your own personal knowledge and or culled from authentic records. So titingnan nga po natin. Darating po ako dito. Ang dami po niyong linagay dito na records, ni wala naman pong authentication. Ni wala pong pumirma kung saan galing po ito. Ito'y galing kay Senator Trillanes and everything. So let me proceed one by one. Tinutulungan na nga kita para for the benefit of the body, we can judiciously decide. Kasi po, while you are a member of the House, you have invoked the jurisdiction of this committee. You have brought a complaint. We have referred it to the proper committee. Let the committee do its job. You are not a member of this committee. You are a complainant. You are appearing here as a complainant. We are the members of this committee. So, sagutin po ninyo. Very simple lang po ito. You already swore to it. So now, do you have personal knowledge of this 1,424 individuals killed in Davao City.
Mr. Chairman, with due respect to
Okay,
the majority
we
leader,
will recognize Congressman Lagman. What is...
we are at the stage of determining sufficiency in form. And sufficiency in form would entail two questions. One, is there a verified complaint? Number two, is the complaint subscribed and sworn to by the complainant? And I think these are answerable in the affirmative. So, with due respect to the Honorable Majority Leader, we should not meander to the substance now. We should first determine the form.
Mr. Chairman.
Mr. Chairman, I have the floor.
okay,
The gentleman from Albay is not a member of this committee either. So, the committee is deliberating. He cannot object. He cannot vote. He has speaking rights, and the chairman was very liberal. In fact, he was allowed to speak even before the members, making and advancing the cause of the complainant by saying that we should hear him, we should be given the opportunity. Well, we are not in that stage. Our rules are very clear. First, let us determine whether it is sufficient in form. And sa form nga po, it's verification. And in the verification, he made an averment, statement under oath, that all the material allegations here are true and correct of his own personal knowledge. So tinitingnan ko po kung tama. Dahil kung hindi naman po, paano? How can this be sufficient in form? Puro hearsay naman po pala yung kanyang sinasabi para po makita natin.
Mr. Chairman.
That is the stage we are in. So
Mr.
I
Chairman.
demand, Mr. Chairman, that my question be answered.
Mr.
Okay,
Chairman,
so
Mr. Chairman, please.
for a while, there is a pending question. The complainant is now being required to answer. This matter has been discussed lengthily, and so we now go back to the complainant who is not a member of this committee and who is being recognized as the complainant. So please remember that this is a constitutional mandate, separate and distinct from the mandate of the entire House of Representatives.
Mr.
That's
Chairman,
why
I will just want to put on
we
record.
are conducting this as a non-lawmaking mandate pursuant to the Constitution.
I just want to put on record, Mr. Chair, that the position taken by the majority leader is correct.
Thank you for
As a
that.
matter of fact, the impeachment complaint will rise and fall within the verification phase. As already stated by the majority leader, paragraph 3 is the main point here. If there is no personal record, personal knowledge, and then it is alleged that the information were culled from authentic records, and if you will simply browse the entirety of the complaint, Mr. Chair, all these records have been sourced from the internet, from the website, and sourced from the articles sourced from the internet. Under the rules, these are inadmissible in evidence. They have no probative value whether objected to or not.
Thank you.
And so,
Thank you
if
for
this
that.
is established, Mr. Chair, then necessarily the impeachment complaint will fall. So, it is correct for the majority leader to insist that before anything else, we should ascertain this.
Thank you,
Because
thank
even
you.
the matter of ascertaining the substance or the sufficiency of form, it cannot escape the verification phase, Mr. Chair.
Thank you, Congressman
Chairman.
Marcoleta. That is really the point that this committee is going to, and so we now
May I
require.
move to the previous question?
Yeah. We now require the complainant to answer the query of the majority leader.
Mr. Chair, yun nga po, I will try to answer the question of the majority floor leader, not only by the yes or no. Am I allowed to explain why?
Yes, first answer with a yes or no if it is answerable by yes or no, and then explain.
Yes,
Pero
Mr.
kung
Chair.
uunahin mo yung explanation mo, gaya kanina, no? Marami kang explanation na sinabi, but at the end of the day, you said no. effectively, no rin pala yun. Para alam na ng membro kung anong hahanapin doon sa explanation mo. So, I think we are well enough to be able to respond to these simple questions. Having sworn to before a notary public and the SecGen on the matter. So, please, para lang for an orderly proceeding in this impeachment case against the highest official of the land, let us please be precise and concise in how we answer the queries.
Mr. Chair, I still insist that I am not given the chance to explain. Now I will proceed.
Are you willing to answer or not?
I will answer, Mr. Chair.
Mr. Chair.
On rule number 3 on the issue
So
of
please
verification.
answer first with an affirmative or a negative and then you explain. That is the ruling of the chair.
Yes, Mr. Chair, I affirm the contents of the verification that I have personal knowledge based on facts culled from authentic records. I just would like to explain, Mr. Chair. Example ho, sa kaso po ni former President Erap Estrada. Meron pong endorsers, meron pong complainants, at meron pong witnesses. Ngayon po, doon sa issue ng bribery at pagbibigay ng 10 milyon sa doon, hindi naman sinabi ng complainant and even the endorsers na nakita nila yung bribery. It was the witnesses. Now, in my case, Mr. Chair, I went through the records, the testimonies of the witnesses. I checked it. I verified it. And the statement of the President, I even went to the extent of getting official records from PCOO. Now, in order to, when I check them, I believe in them, and comparing the testimonies in the affidavits, I believe
Point of order,
that,
Mr. Chairman.
Mr. Chair, I am
the point of
explaining,
order?
Mr. Chair.
Is that responding to the rule says that he should answer the question because we are not determining the sufficiency. Does he have personal knowledge? Alam ko naman na ang sagot mo, hindi. We all know. Because how could you have been there or have personal knowledge of 1,424 kills? And I will show later on that the affiant and complainant himself clearly contradicts himself by saying that according to Matubato, according to Las Cañas, clearly he is saying that these are not of his personal knowledge because he is testifying for another person. So dapat si Las Cañas o si Matubato ang nanumpa rito at in-endorse po ninyo. Ang nangyari po wala, kayo po ang, you took it upon yourself to state that all the contents of this, all the material, hindi po ba material allegation ito? That's the first part of your complaint. You're saying na 8,000 namatay. Ni isa, wala ho kayong alam eh. May 10, wala. And now, you're going back as far as the Davao Death Squad. You claim that 1,000. And if you look at it, if I proceed, as brought about by Honorable Marcoleta, makikita po dito sa mga footnote, galing po lahat sa newspaper eh. Or editorial and everything. Hindi po naman niya personal knowledge. Ito po, nakalagay po dito, public speaking in paragraph 2, page 3. Nasa page 3 pa lang po tayo. Ang footnote niya, Philip C. Guardian Staff, the Guardian by Staff and Agencies, Guardian Staff. Ito po yung report ng Guardian Staff. Footnote number 2, C. Victims of Davao Death Squad, consolidated report by Father Amado Picardal, who is not here. We cannot even cross-examine this person. These are all hearsay. Then, again, if you proceed, next paragraph, C. Be Not Afraid to Kill Drug Traders by Marlon Ramos, Philippine Daily Inquirer. All of these are newspaper reports, and newspaper reports are not authentic records that we are talking about. These are, so let us jump, Mr. Chairman, so that we can proceed. So,
Please proceed.
very clearly,
Mr. Chair, may I answer?
you do not have personal knowledge of the killing of 1,425 in Davao when Rodrigo Duterte was mayor.
I have no personal knowledge of
Thank
the
you.
witness, but I have personal knowledge as a complainant based on the records of the witnesses.
Okay, you
Okay.
may answer that way. That will be clear enough.
And then, again, clearly, paragraph 10, it states under oath, organizing and or maintaining liquidation squads. Kasi po, let me just segue a bit. You are filing a complaint against the highest official of the land. Dinadala po ito sa United Nations. Puro naman po, the Senate conducted a hearing on this Matubato and Las Cañas, and they came out with a report. The Committee on Justice of the Senate, we should respect the findings of the other chamber. Nagka-hearing po dyan and they were all heard, and they came out with the report. And now, we are reproducing the testimony there to be the basis of an impeachment complaint against the highest official of the land. Let me proceed. Paragraph 10, you stated under oath, organizing and or maintaining liquidation squads under the guise of anti-crime task forces, special police units like Davao's heinous crimes unit, and or vigilante groups like the dreaded Davao Death Squad, and or providing funds to the said groups, whether in the form of salaries, nakakatakot po itong mga allegations, monthly allowances, bounties, rewards, and or prize money for doing his bidding, and or executing his orders to kill crime suspects, as testified to by Edgar B. Matubato and SPO3 Arthur Las Cañas of the Senate. By the form alone, he is already saying that these are not true and correct of his own personal knowledge. But he heard, clearly, sinasabi nga nyo, hearsay ito mo eh. Dahil ang nagsasabi po nito ay si Las Cañas at si Matubato, not you. Is that correct?
Mr. Chair, I confirm that I am not the witness. I confirm that in my own personal knowledge based on the testimonies and affidavits of the witnesses. I went through the records and I have personal knowledge. Now, on the issue of the Senate Justice Committee, Mr. Chair, hindi naman ho natapos ang committee. In fact, wala pang official report ang Senate Justice Committee. Ang point na doon, Mr. Chair, I went through the records, I saw the testimonies, and I affirmed that through my personal knowledge, I went through it, and I believe in it, Mr. Chair. Now, when we go to the presentation of evidence, I will present the witnesses, Mr. Chair.
Mr. Chairman, now, clearly, it is not of his personal knowledge. That is the defect here. Kaya nga ho required speculation yan. Even that allegation, you are testifying on what Matubato and Las Cañas said, which is not allowed kasi hindi ko kayo lawyer eh. So, kami ho, kung susunod kami sa inyo, dadalhin namin to sa Senado, di nagmukhang gago kami doon dahil magdadala kami ng ebidensya doon na puro hearsay po eh. Hindi naman. So, let me proceed. Then, from the Philippine Daily Inquirer, let's go to paragraph 2, charge number 2. Nakalagay naman po dito, page 6. Inulit po niya yung 1,400 persons, which we already know na hindi po niya alam. Then, ganun na naman. Clearly admitting under oath in page 6 that under the patronage backing, inulit po niya, Duterte's group espoused and pursued a policy of killing crime suspects, political and personal enemies, and even innocent civilians, including women and children, sans any trial and or due process of law, as testified to by both Mr. Matubato and SPO for Arthur Las Cañas. On the face of the document, res ipsa loquitur, dito na lang po, pinapakita mo na lang, hindi mo personal knowledge po itong mga sinasabi mo, at bawal po yan. You are introducing statements under oath which are not your own. Bawal po yan. Ayan ang trabaho namin dito dahil ayan po, kung saan nalalabas yan, lalabas dyan, hearsay po ito eh. Then, again, the next paragraph, as testified to by Mr. Edgar Matubato and SPO3 Arturo Las Cañas, and as will be affirmed by other witnesses against him. Sino itong mga ito? Respondent Duterte offered and gave by himself and through his subalterns prize money, rewards, and or bounties. Ganun naman po eh. So, inaamin na nga niya. And then, inulit na naman po, 1,424 ang namatay. So, charge number 3. Yun lang po laman ng charge number 2, yung kay Matubato at Las Cañas. Charge number 3, graft and corruption and other high crimes. Sometime in 2015, sabi naman po niya, page 8, this is the third charge. The Commission on Audit came up with a report questioning the hiring of 11,000 contractual workers in 2014 by Davao City now under President and former Davao City Mayor Duterte. Wala naman po siyang sinasabi, wala binibigay na audit report. Tapos ang isa side na, the COA further claim, ang source po niya, Rappler. Paano po maging authentic records po yung Rappler? Ito, you stated under oath, the COA further claim, the city has no written policy or manual on the hiring of employees, particularly under contract of services and job orders. Identification of persons to be hired for such nature rests directly upon the recommendation of the department heads and other officials of the city. These conditions cast doubt that entries in the daily time record of these employees are manipulated, thus regularity and validity of the related expenditures could not be ascertained, the COA report said. Footnote 17. Titignan mo yung footnote ng 17 po. See COA questions Duterte's 11,000 contractual employees, Rappler.com, June 15. Paano po, hindi naman po authentic records po ito eh. And then, alam po naman ninyo, kung talagang may finding ang COA, that will result to suspension. After suspension, it will resort to disallowance. And then pag disallowance, pababayarin na sana si Rodrigo Duterte ng COA, pero wala naman pong ganyan nangyari. So, we are already introducing so many statements here na, do you have any authentic record of this 11,000 employees being employed by then Mayor Rodrigo Duterte? That is my question, Mr. Chairman.
Point of information lang, in a case that you filed before the Supreme Court, for example, when you say authenticated records, dapat yan authenticated by an authentication officer na nakamark yan. And without which that will be considered a mere scrap of paper that will be the basis for dismissal of any petition filed before the courts of law. So another point that you have to consider if you want to be a complainant in an impeachment case, kasi hindi ito yung kapareho ng ginagawa natin sa other committees. That's why we are giving highest priority to impeachment cases, because this is a different mandate that the House of Representatives, through the Committee on Justice. Bakit Committee on Justice? Kasi nga law ang pinag-uusapan natin dito, and there are requirements when you file a complaint. Has to be personal knowledge, not hearsay. Evidence and authentication are very important ingredients in filing mga ganito, mga complaints, petitions, and the like. No? So,
Mr. Chairman,
yung tanong ngayon na pakisagot, puro hindi daw authenticated. What can you say about that?
Mr. Chair, it stated there that the file is culled from authentic records, including the news reports regarding the authentic records. Now, Mr. Chair, I understand we are not yet in a stage where we will present the evidence. There's no marking of evidence yet. So, kaya nga, Mr. Chair, ang sinasabi ho natin, my allegations are based on authentic records.
Mr. Chairman, where is the authentic record here? Did he submit any authentic record? Because you stated under oath that all your material allegations are based on authentic records. Can you show us any authentic record in your complaint?
Mr. Chair, ang nakalagay po doon, based on authentic records, not authenticated records. So yun po yung aking pagkakaintindi, Mr. Chair.
Yes, sir.
We will submit authentic records or authenticated records once we're given the chance to present the evidence, Mr. Chair.
Mr. Chairman, my question is, so where is the authentic record that you have produced here?
In a proper time, Mr. Chair, we will present the authentic records. We have, Mr. Chair.
Okay, so anyway,
so the answer is no.
There is none.
Okay.
He will present it at the proper time. Para lang malinaw, no? Because we're going through this one by one para malinaw. And this is not only for our own education, but for the better understanding of the general public.
May I proceed, Mr. Chairman? Kasi po, intindihin po ninyo, Mr. Complainant, I've been a member of the Committee on Justice in all the terms that I was here in Congress. I was chair of this committee once. This is the only committee created by the Constitution or referred to by the Constitution. Wala pong ibang committee ng Congress, maski sa Senado. Ito lang po. Any impeachment complaint shall be referred to the appropriate committee. So this is a constitutional body. We are performing a constitutional function. Napaka-importante po nito. Hindi po ito, like the chair said, hindi po ito yung inquiries in aid of legislation na pwedeng magsalita ka na lang, resolution, then you call everybody, then you make an opening statement, you ask questions, then you produce, you subpoena document. Hindi po. Very limited officials po ito, yung pinakamataas. At ito na nga po yung mga sinabi ko sa impeachment court noon. Hindi po biro-biro ito. All other officials po, file mo lang sa ombudsman, pwede na matanggal ng ombudsman yan, pwede na masuspindi yan. Ito po, hindi po. Yung president, vice president, members of the Supreme Court, members of constitutional commissions, and the ombudsman, select group po ito. Para po maalis mo sa trabaho, kailangan dumaan sa Kongreso to initiate in the House of Representatives. Kailangan po i-endorse ng isang member. Kailangan verified. Kaya nga ho yung verification nyo, nakalagay doon that all the material allegations here are true and correct of your own personal knowledge. Kaya hindi ho pwede yung, at saka na yan, saka, presidente po ito eh. In fact, may immunity from suit nga ho, presidente. Kasi hindi na makakatrabaho yan kung talagang lahat ng Juan de la Cruz yan, magpa-file na lang siya ng complaint, wala na siyang trabaho, hindi na makakatrabaho sa kasasagot. Kaya nga ho dito, kailangan, hinihimay nga ho natin eh. Ang problema po dito, you took it upon yourself to state under oath that the material allegations of your complaint are true and correct of your own personal knowledge. But now you're saying na hindi pala. Ito pala eh, sinabi ni Matubato, ito ay magwagaling sa mga records. Get your records first, get everything, and then present it here para po naman hindi sayang yung trabaho natin dito.
And yun na nga, strictest rules itong ina-apply natin because that is what the law requires. This was covered by my opening remarks nung sinabi ko kanina. And anyway, thank you, Professor Fariñas,
Mr. Chairman,
for educating
may I respond?
May I just proceed? Mr. Chairman, let me finish. Then, another paragraph here on page 9. Based on the testimonies of Mr. Matubato and Las Cañas, this clearly constitutes offense of graft and corruption. Eh, yung pong statement lang ni Las Cañas, eh, yun na ang kanyang basehan para maging graft and corruption against the highest official of the land. Then proceed. Unexplained wealth. Based on documents given to the Honorable Antonio Trillanes. Hindi mo alam kung saan nanggaling eh. And then, annexes niya po ay 48 pages. Annexes 8 to F. Eh wala naman pong, hindi natin malaman may I ask now, gentlemen, who prepared this document? Itong annexes A to F, saan po nang galing ito? Are they culled from authentic records?
Mr. Chair, yung sa records ng properties and then the COA, they're culled from authentic records. Now, the issue on the bank accounts, we understand, Mr. Chair, that it is only through a litigation or hearing or of a case, an impeachment court that the bank secrecy law will be waived.
So you do not have any authentic records of these allegations?
It's just allegation, Mr. Chair.
Yun
the
na nga
bank
po.
records.
You are using this committee to fish evidence.
We cannot produce that, Mr. Chair, out of the banks.
Precisely. And then you stated under oath that your material allegations, I will read now. Oh, you said here, Senator Trillanes asked the help of accountants and finance specialists to tally and figure out just how much money was actually deposited and or transferred into the subject bank accounts. Their final tally shows 2.207 billion more or less. Isinasabi po niyo ito under oath, tapos chismis lang po ito eh. Wala po kayong authentic records.
Mr. Chair, again po, yung authentic records na yan po, sinabi po ng nagbigay po sa kay Senator Trillanes na nakuha niya po doon sa kanyang sa ombudsman. There's authentic records, but of course,
kumbaga sa bypass po ito, hindi quadruple bypass na ito, hindi quadruple hearsay po ito, multiple
kaya nga Mr. Chair,
complicated hearsay na po ito hindi po natin alam kung sino nagbigay ng mga records na yan eh. And then, pwede po sana si Senator Trillanes na ang nag-complainant dito para makita natin, sagutin niya dito. Ngayon po, binigay ng sino man tao na yan, binigay kay Senator Trillanes, nabigay sa'yo, then you want the House of Representatives to make the highest official of the land answerable for hearsay evidence. Mahirap po ito.
Mr. Chair,
In fact,
kaya nga po, Mr. Chair, may I respond, Mr. Chair?
Just before that, if you will recall in the impeachment of Chief Justice Corona, we were not even allowed to look at the records during the Senate impeachment trial of PS Bank. Yung PS Bank at saka yung BPI at saka meron pa isang bangko. Sinumpinan na ng Senate. Pero wala rin. Hindi rin dahil hindi nga pwede yun. So again, this is a clear showing na you want this committee to consider your complaint on the basis of something that we cannot even produce, even during the previous experience that we had on former Chief Justice Corona. Hindi namin nakuha ito. Tiniro pa kami ng PS Bank. So, anong saysay nitong pinag-uusapan natin? So, you are testifying not even of your personal knowledge. Sana, sabi nga ni Majority Leader, di sana hindi rin namin alam kung personal knowledge ang kay Senator Trillanes dito. Baka naman kung saan-saan niya nakuha. Anyway,
Mr.
you are
Chair,
now recognized.
Kaya nga po, Mr. Chair, ang sinasabi ko po kanina pa, na yung personal knowledge ko, I have went through the documents and I believe that these are true based on authentic records, Mr. Chair. Ngayon po, on the proper time, kung totoo pong hindi ito totoo na yung mga bank accounts, then we can subpoena the records from AMLAC and the Ombudsman, Mr.
Okay.
Chair.
May I just request one of our distinguished lawyers in the committee, Vice Chairman Doyle Liachon, can you please give us some clarification para lang mas malinaw what is personal knowledge, what is hearsay evidence, and so on and so on, what is multiple hearsay and the like.
Yeah, thank you, Mr. Chair, and of course, thank you, Majority Leader, with your permission. Kanina po sinasabi po ng ating complainant, ni Congressman Alejano, napaka-importante po nito dahil Pangulo. Totoo yun, wala akong question doon. Kaya nga, ganong kahalaga yun, kaya dapat malaman natin kung gano'n rin katotoo ito. Para po sa kaalaman ng publiko, pag naghahabla ka, kailangan alam mo sa sarili mo. Ang naka-require po sa batas, dapat nakita mo. Pag hindi mo nakita, hearsay po yun, hindi tinatanggap na ebidensya. Pag wala po tayong nailagay rito na mga ebidensya, ang tawag po doon ay fishing expedition. Kaya po, alam ko, our esteemed colleague, Congressman Alejano, would like to be clarified here. Ang dami po ng tinanong po ng ating gagalang-galang na Majority Leader, ang bank accounts so dapat certified true copy. Dapat yung nakita yung patayan, ikaw ang nakakita. Pag iba ang nakakita, dapat siya na lang nagdemanda rito. Ngayon po, we're not dealing here just with a procedural requirement. We are dealing here, as it is mandated by the Constitution, this is not a mere procedure. This is a constitutional requirement. Now, ang akin po, Mr. Chair, na katanungan, alam ko po marami na natanong si Majority Leader. Ang tanong ko lang po na pwede po itanong, kung wala po siyang personal na kaalaman dito, pwede ho bang sabihin na lang dito kung anong alam niya doon sa lahat ng inilista rito para doon na lang tayo magbasehan. Otherwise, if the statements, contrary to the statements in the verification, nakalagay po dan that according to my own personal knowledge and authentic records, kung hindi po yun totoo dahil sabi po niya ay hindi, this is a defective verification, and considering this is a defective verification, there is a constitutional infringement of the complaint, in which case, outright dismissal ang ating kaso. Pero narinig ko po, based on ng pinag-aaralan, we want really to clear the matter. Ngayon po, Mr. Chair, thank you for the opportunity. Ang akin lang po, kung walang alam siya sa lahat ng inilista niya ron, ano po yung alam niya sa personal niya para mas mabilis po tayo? Thank you, Mr. Chair.
Of course, that was a manifestation that, but it is the majority leader who has the floor, and
Proceed, Mr. Chairman.
please proceed.
Okay, ito na rin po. Annex A. Can you look at your Annex A? Is this an authentic record? There's even no proper marking, so I'm at a loss. It says here, Rodrigo Roa Duterte, there is a matrix of names, addresses, banks, and amounts. Where did you get, who prepared this Annex A, Mr. Complainant? Did you prepare it?
Mr. Chair, my lawyers prepared this, and I have checked this, and I agree that there are, I believe in this document, Mr. Chair.
Where is the authentic here? Who issued this? Your lawyers?
Mr. Chair, gaya po ng sabi ko kanina, these are based on the records that I saw, Mr. Chair. And at the proper time, through the powers of the committee, then we can find out really if this is through the subpoena powers of the committee. We can require AMLAC to present the documents, Mr.
Can you just imagine, Mr. Chairman, and I'm telling this as a guidance to all members of the House of Representatives. Sama mo yung justices of the Supreme Court, sama mo yung ombudsman, sama mo yung para hanapan sila ng mga ebidensya, isubpina natin lahat. Hindi po yun ang trabaho ng committee, fishing evidence na po yan. Kaya nga po sila elevated to the highest levels of removal from office only by impeachment para hindi po maharas yan. Kaya nga hindi pwede maski sino-sino, maski ilang milyon ang magpa-file ng complaint, pag walang mag-endorse na isang member, hindi po uusad yun. Yan po ang konstitusyon natin. Ang problema po nga dito, kayo po ang tumatayong complainant, pero wala naman po kayong kaalam-alam sa lahat ng sinasabi dito. Authentic, personally, not true and correct of your own. In fact, delikado po kayo rito sa perjury. Because you stated under oath that all the material allegations here are true and correct of your own personal knowledge, hindi or and culled from authentic records. Very clear po, maski isa, wala pong authentic record dito eh. Not even the alleged COA report. Ang dali ho kumuha sa COA, hindi kayo kumuha eh. Para iatas nyo dito, sinasite nyo lang yung Rappler na sila ang nagsabi nun. Maski nga po, mayor o governor lang, hindi mahirap pong file ng, ito po, presidente po ito. At nakita nyo man po lahat, nakikinig tayo rito for this. So, now, let me proceed. Annex A, wala rin po. Annex B. Can you look at your Annex B? Copies of the respective summaries of the transaction of the President Duterte's children as listed above. Alam naman po ninyo, violation of rights na nito ng mga anak ni Presidente dahil bawal naman po tumingin ng mga secrecy of bank deposits. You're making this committee private to commission of illegal activities. Saan po nila nakuha ito? Was there an impeachment court that authorized the release of these documents? Meron po ba?
Mr. Chair, ulit po, sinasabi ko po, ito ay binigay lang po ayon doon sa report sa Ombudsman. Binigay po kay Senator Trillanes, and nakita ko po yung record, and I believe in this, Mr. Chair.
Anong record po yung nakita nyo? Sino po nag-issue nun? Was there a bank that certified na yan may deposit? Ito, halimbawa, Sara Duterte, 121 million pesos. Where did you base this amount?
Kaya Mr. Chair, sinasabi ko po nga, yung records ay based doon sa record ng AMLAC report. Yun yung record na nakuha po ng the person that got that from the Ombudsman.
Who is this person?
Yun nga po, according to the affidavit of Senator Trillanes, a certain De Mesa, Mr. Chair.
You heard him, Your Honors, according to the affidavit of Senator Trillanes. An affidavit is hearsay by itself, unless it has been subjected to cross-examination. So hearsay na ngayon affidavit ni Senator Trillanes, yung pa ang basis mo as authentic records. Kaya nga sinasabi ko, multiple hearsay na po ito, quadruple hearsay. At mahirap naman po to drag the whole House into things like this, and then you're expecting na we will issue the subpoena, yung impeachment court lang po ang pwede mag-issue niyan. kung isasampa po natin. Ngayon, in the meantime, propaganda po nangyayari dito. Which is, pardon my saying it, ginawa po ni Senator Trillanes na magdalo sa Senado yan. Pinanagot at inakusa si Presidente, wala pong nangyari. Ginagawa niyo rin po dito eh. So parang stereo po itong nangyayari. You are now coming to us and in fact, I am warning you, Your Honor, you may be subjected to ethics case here. Because you are stating under oath, now you are saying that hindi naman pala totoo yung verification nyo. That these are of your personal knowledge.
Mr. Chair, I stand by my statement, Mr. Chair, that when I saw the documents, the different affidavits with the witnesses, I believe that I checked these statements based on what I have seen and based on the authentic records.
Okay. So, Mr. Chairman, may I get a categorical? So, all of your allegations are based on information coming from other persons. You do not have any personal knowledge. Yung talagang alam mo mismo, nakita mo mismo, perceiving as a man of sound mind, nakita mo and makita mo, makwento mo sa amin. Is there such any allegation here na galing sa sarili mo perception?
No, Mr. Chair.
Okay.
My personal knowledge is based on the records when I browsed through it and checked with the statements of the President.
I am done, Mr. Chairman.
Thank you for that. So, marami na tayong na-cover. I think the committee is about ready to already determine the sufficiency in form of this particular impeachment complaint.
Mr. Chair,
Move for a vote.
Mr. Chair,
So,
Mr. Chair, may I have
what is the pleasure of Vice Chair Uaminal?
Mr. Chairman.
I have the chair, Mr. Chair. I have the floor. I'm sorry. Mr. Chair, this humble representation fully agrees and in accord with the observation of the majority members as cited and well presented by our majority leader. However, Mr. Chair, I still believe that for the best interest of the nation, that this committee should take a liberality in handling this impeachment complaint. I fully agree on the noted deficiencies and the technicalities raised by the majority leader insofar as the complaint is concerned. However, the Supreme Court, in so many landmark cases, had set aside technicality in furtherance to substantial justice. In that connection, Mr. Chair, I move that the committee would be liberal enough and declare the complaint sufficient in form, considering that under Rule 2 of our impeachment complaint, it also provided a minimum requirement, and that is the verification if it is filed by the complainant who is a member himself. So, I therefore move to that effect, Mr. Chair.
Mr. Chairman. Mr. Chairman.
Let me clarify. What is your motion,
Mr. Chairman.
Your Honor? Your motion is to...
My motion is for the committee to declare the complaint sufficient in form and be liberal enough in setting aside the noted deficiencies and technicalities in the complaint.
Mr. Chairman.
Any second?
No, Mr. Chair.
I have a prior
Any
motion.
objection?
I object, Mr. Chairman.
Objection, Your Honor.
Mr.
Okay,
Chairman.
let us hear the objections.
Objection.
Mr. Chairman, to proceed hearing an impeachment complaint.
Point of order, Mr. Chairman. It has not been seconded. Because if it's not seconded, it's a dead motion.
Your Honor.
Not second.
Any second
before we
to the
object,
motion?
let's hear if there's a
Objection.
second.
Objection.
Walang second. Kung there's no second, it's a dead motion.
On dead motion.
I second the motion, Mr. Chair.
Mr. Chairman.
Who is that? Congressman Belaro seconded. So
Mr.
There
Chairman,
is an objection. I see three microphones on the red.
Mr. Chairman, I object to the motion of Congressman Uminal. The objection is based on the fact that if this committee proceeds hearing this impeachment complaint, we will be proceeding on the basis of hearsay evidence. With that, Mr. Chairman, not only that we are violating our rules, that it should be based on personal knowledge, but we will be violating the very essence of what is the truth, what is right, and what is proper in any impeachment proceeding. Mr. Chairman, let this proceeding and let this impeachment complaint be an example to everybody, not only now, but in the future, that you cannot make a joke and by utilizing falsities as well as hearsay evidence in trying to remove someone, especially one that occupies the highest position in the land based on hearsay evidence. And let it also be an example to all concerned, especially the members of the House, that you cannot make a joke of this proceeding. Along this line, Mr. Chairman, I move for the dismissal of the impeachment complaint.
Mr. Chair,
We will now recognize Congress Vice Chairman Veloso and then
Please divide the House.
And then Vice Chair Lachon and Congressman Ron Salo. So, but you have a point of order? What
yes,
is your
Your
point
Honor.
of order?
Because prior to Congressman Ominal's motion, I had the motion duly seconded. And the motion was for the committee to vote on sufficiency on substance, which is different from the motion. On form, I stand corrected. No? So that motion, duly seconded, stands.
Anyway,
prior to the motion of our good colleague, no? Congressman Ominal, who moved that it be sustained, no, on the issue of form.
Mr. Chairman.
Anyway, I don't recall that particular aspect of your motion being seconded. So anyway, that has been overtaken by events. And so there is now a pending motion, duly seconded, objected to by Deputy Speaker Castro, and now we recognize Congressman Veloso.
Mr. Chairman, under the rules of procedure on impeachment proceeding, we have here Section 13, Rule 4, which says, the contents of the verification shall be as follows. We, after being sworn in accordance with law, depose and state that we are the complainants in the above entitled impeachment complaint resolution, that we have caused the said complaint resolution to be prepared and have read the contents thereof, and that the allegations therein are true of our own knowledge and belief on the basis of our reading and appreciation of documents and other records pertinent thereto. Speaking of form, Mr. Chairman, the verification of complainant Alejano substantially conforms to Section 13. The problem, though, is that while we were discussing on sufficiency or insufficiency of form, the majority leader raised very important points. Those important points, Mr. Chairman, to me, are not lost if we will go ahead to the sufficiency of substance aspect of the complaint. I can understand where complainant Alejano is coming from. He's not a lawyer. He's not aware, therefore, of the provisions in Section 36, Rule 130 of the Rules of Court, which says that a witness can testify only on matters of his own perception. Meaning, kung anong nakita niya, yun lang ang pwede niyang sabihin. Kung anong narinig niya personally doon sa commission of the crime, yun lang. He says matters of record. This to me, Mr. Chairman, are matters that should be verified sa deliberation natin on substance. So, I join Vice Chair Waminal in his request that we go ahead with the impeachment complaint. Huwag namang patayin kaagad ito dahil lang sa insufficiency on form, because there has been a substantial compliance form-wise in the complaint. May substantial compliance form-wise. Give a non-lawyer complainant an added mileage, speaking of due process. Yun lang po. Salamat, Mr. Chairman.
Congressman Roque is now recognized.
Well, Mr. Chair, there is something that really disturbs me with the verification, which is why I think it should be dismissed, even on the issue of form. I quote for the record what the complainant said. I, the undersigned member of the House of Representatives, in our own behalf and in behalf of the people of the Republic of the Philippines. At best, this is a misrepresentation. At worst, it's a falsity. We could all claim as members of the House that we are representatives of the people. I don't think the complainant in this case could allege in his verification that he's filing it on behalf of the people of the Philippines, not when in the last elections the person sought to be removed received 16 million votes, constituting an overwhelming majority of the mandate of the people. So on this ground alone, I think this is a patent falsity. I believe it should be dismissed on the basis of form. And let us not take this lightly. We are all representatives, but I don't think any one of us can claim to be like Jesus Christ, no, and claim that he is the only representative of the people, which the verification contains. And that is why I maintain that we should vote, and my vote will be to dismiss on the basis of lack of form. Thank you, Mr. Chair.
Mr. Chairman, my last word.
Thank you for that. Before that, we have already mentioned the members who will be recognized. Congressman Doyle Liachon. We will go back to you, Vice Chairman Veloso.
Thank you, Mr. Chair. With all due respect to my co-vice chairs, well, the present activity that we're having right now is definitely an explicit indication that democracy is working in this country. For which reason is always the reason that we are always mighty proud that we are living in a democratic country as unified, robust community as viewed from the world. The impeachment today that we're having right now definitely again proves that there is no smoking gun in the Constitution, that there's no specific provision stating that the President is immune from any suit. But while the President is immune from all judicial process, we have here our impeachment. And our impeachment is the safeguard of the people from all abuses being committed by the highest official of the land. But then, if I may tell you, this is democracy, but is it all that matters? Mr. Chair, for this representation, while I must admit initially that we should give way to a full-blown hearing on the substance of the complaint, with the intelligent discourse and direct examination on part of the majority leader, I was really perplexed on how the answers were given. And on the larger note, Mr. Chairman, alam niyo po, ang bansa ho natin, for the last presidency, tayo ho ay magandang bansa noon. And since 1986, this government and this country has been crying out for a good government. 7 na po yung atin na naging Pangulo, tatlo po doon, either depose, impeach, or imprison. Ang sabi ho ng isang ordinaryong tao at kilala na ekonomista, kaya daw ho naiwanan tayo ay laging masyadong mataas ang politika at pinagpapaalis ang Pangulo. Now, on my own, in my conscience, I cannot definitely permit, while admitting the seriousness of a charge, hindi ho pwedeng gamitin ang komite na ito as an instrument to further na magulo pa yung bansa natin. The information and verification being supplied by a complainant, of course, with due respect to our esteemed colleague Congressman Alejano, definitely that cannot stand in this committee. And for which reason, I concur with the Deputy Speaker, Fredenil Castro. I'm opposing that we deal with the subject matter on substance, but definitely I am invoking my position, Mr. Chair, that the impeachment complaint is definitely constitutionally infringed as a defective verification, and for which reason it warrants outright dismissal of the complaint. Thank you, Mr. Chair.
Thank you, Vice Chair Liachon. Congressman Ronzalo. Should anyone wish to make any manifestation, please cause your name to be registered with the COMSEC.
Thank you very much, Mr. Chair. I completely agree with all the statements made by our esteemed colleagues that indeed democracy is working in this country. Nonetheless, I just go back to the rules, and may I just respectfully put forward the rules of this particular committee. Of course, it was already mentioned by the Honorable Senior Vice Chairman, Vicente Veloso, with respect to the required verification that was stated or provided for under our rules. And precisely, Your Honor, if you will note, if you will just read the provided verification under Section 13, the verification made in the complaint is not compliant. But whether or not there was substantial compliance is another matter. And that's for the determination of each and every one of us, considering also the jurisprudence on this matter, where the Supreme Court has always said that on matters of verification, these are matters for formalities in which we can extend liberality to it. Meantime, I may just mention to this honorable committee the procedure also provided for under rules, in the sense that most of our colleagues are stating that we should dismiss it outright, in the sense that Section 4 provides here that the committee, upon referral, the Committee on Justice shall determine whether the complaint is sufficient in form and substance. If the committee finds that the complaint is insufficient in form, then it shall return the same to the Secretary General within 3 session days with a written explanation of the insufficiency. The Secretary General shall return the same to the complainants together with the committee's written explanation within 3 session days from receipt of the committee resolution finding the complaint insufficient in form. I just hope that I'm not putting the cart before the horse. I'm just stating it that this particular provision is provided for under our rules, wherein, in case the committee finds that the complaint is insufficient in form, then the rules provides itself on what would be the next step. Thank you very much, Mr. Chair.
Mr. Chairman, I move for the previous question so that we can already vote. There's a previous question, Mr. Chairman. Why don't we divide already the committee?
We will, as mentioned, we will allow extensive discussion, and we have already listed those to be recognized. Congressman Veloso, Congressman Sandoval, Congressman Lagman, Congressman Belaro, Congressman Marcoleta, and Congressman Tugna. They have already manifested their desire to make their own separate manifestation, and Deputy Speaker Aboeg. So we would like to hear the members and the sentiments of the members on this, because it has become so divisive that we really need to hear our members, especially the members of the Committee on Justice. Okay, Congressman Veloso.
Mr. Chairman, ang point ko lang po is this. under Section 4, if we rule that the impeachment complaint is insufficient in form, we have no choice. Ibabalik natin ito sa section. And then, inayos lang po ni complainant, balik na naman po tayo dito. And it may take us 1 year. But, kung magpapatuloy, I do not need 10 minutes, Mr. Chairman. Pagdating sa deliberation on substance, tatanungin ko lang po si complainant Alejano. Sinabi mo kanina na wala kang personal knowledge dito sa complaint mo. Inaamin mo ba ito dito sa deliberation na natin on substance? He has no choice but to admit na wala siyang personal knowledge. And that on that premise alone, Mr. Chairman, pwede na nating i-dismiss ang substance aspect of it. Tapos na. Hindi na tayo mag-aantay ng ilang buwan pa.
The chair would like to ask our esteemed vice chairman, who was a former justice of the Court of Appeals. Based on your reading of Section 4, first paragraph, ano ho ang implication when the committee finds the complaint insufficient in form? So, binalik natin sa SecGen, 3 session days. The SecGen shall return the same to complainants together with the committee's written explanation within 3 session days again. And then, period. Sinasabi na yung finding natin insufficient in form. Anong implication nun?
Well, ang implication dyan is it can be corrected. Hindi papasok yung Section 14, Rule 5. No impeachment proceedings shall be initiated against the same official more than once within a period of 1 year. Bakit? Under our rules, hindi pa ito umabot sa foreclosing initiation. Okay? Hindi pa natin kasi tinalakay ang substance.
Ibig nyo sabihin, kailangan may categorical statement na dismiss ito para mag-apply yung 1-year bar rule.
We should have a ruling na insufficient ito in substance. Then, with that, papasok ng Section 14.
Hindi, kanya ko lang tinatanong ito para sa kalinawan ng bawat isa. No? Mamaya, pag-uusapan natin ito. That is your understanding. I do not know how the others would see this particular provision. So anyway, you're done with your remarks. May we now recognize Congressman Sandoval?
Maraming salamat po, Mr. Chairman. Just a point for information. In the 11th Congress, I filed for the impeachment of COMELEC commissioners. And in 2 months' time, going around members of the House, I was able to get 77 signatures on the impeachment of the COMELEC commissioner. 77 po. I had 1/3 of the vote. So on plenary, I was asked whether I believe that the impeachment complaint should go directly to the Senate. And I answered yes, because that was the rules during the time. However, the rules of the 10th Congress was not yet approved on plenary. And the Committee on Rules revised the rules of impeachment of the 10th Congress, asking precisely for the verification and the swearing in to the Secretary General. Bakit po? Dahil nakita ng Kongreso na napakadali pa lang mag-impeach ng mga constitutional bodies. At dahil po dito, nagkaroon po, alam to ni Congressman Bondok during the time, dahil siya ay member ng Rules 10, kaya po pinahirap mismo ng rules natin ang pag-file ng impeachment complaint. Kaya pagkatapos po nito, nagkaroon tayo ng impeachment kay President Estrada, yung rules po ng verification ay i-adapt natin. However, naging liberal po ang interpretasyon ng Congress na yon, doon po sa personal knowledge and belief. Dahil po, kung lahat tayo ay may personal knowledge, wala pong talagang personal knowledge. Pero dinagdag po yung belief. Kung ikaw ay naniniwala na ito ay totoo at ito ay tunay, pwede kang mag-endorse. Point of information lang po yun, Mr. Chairman, dahil po siguro baka dapat pag-usapan natin yung belief po. Maraming salamat po, Mr. Chairman.
Thank you very much. The Honorable Congressman Lagman is recognized.
Thank you, Mr. Chairman. I am aware I am not a member of this committee, but I am a member of the House. And I have the right to voice my opinion or statements even without a vote. I regret that despite several applications, the Honorable Majority Leader has refused to recommend my membership to this committee. He must have his own reasons for that. Well, with respect to form, let me reiterate that there are only two questions to be asked. Is there a verified complaint? Number two, has the complainant subscribed and sworn to the complaint? We are not going outside of the periphery of the verification. If we do that, then we are now venturing on the question of substance. But we are still with respect to form. And even in the previous Congresses, we have not done in validating the form by going through other matters outside of the verification. And the Supreme Court, in a cantina of cases, has underscored that there should be liberality in the appreciation of verification. Now, because that is with respect only to form, the more stringent requirement would be with respect to the recital of facts constituting the offense charge and determinative of the jurisdiction of the committee. That is why, before we jettison the complaint of the Honorable Alejano, we should give him the opportunity to be heard with respect to the form and substance of his complaint, because he is entitled to a hearing as required by the Constitution. Thank you, Mr. Chairman.
We now recognize Congressman Bilaro.
Good morning, Mr. Chairman. We should be governed by the rule of law. Now, I think there's a fundamental misunderstanding here with respect to the timelines. Because I just checked before coming to this hearing the procedure of the House Committee on Justice on impeachment. And I confirmed also with the committee secretary that the 16th Congress rules of the House on impeachment was amended last August 2016. And I think that should be current. It should be governed by it. Now, I think the misunderstanding of many members of the House, many members of the public attending today's hearing is that it seems to them that the determination of form and the determination of substance could be spatially apart in time. But that should not be the case. What is provided in Section 2 is that the Committee on Justice should first determine the form, the sufficiency of the form, and thereafter, the sufficiency of substance. And the sufficiency of substance, there are two things. One, whether this committee has jurisdiction over the offense charged, and whether there is a recital of the elements of the offense. And then thereafter, in Section 3, the following section, there is now a full-blown trial. So I'm wondering where this confusion is coming from. We should be governed by our own rules. We should follow the rule of law. It can only be done in 1 hour. First, we vote on the matter of the sufficiency of form. And the position of this representation is that in support of his secondment of the seconding the motion of Congressman Rominal is that we should be liberal in the appreciation of form, because here, while I defer to the comment of the esteemed legislator Edsi Lagman that this is also partakes of a judicial process, we are not here sitting as judges. We are sitting here as elected representatives of the people. And these jurisprudence on the Supreme Court are just persuasive in effect, because we have to be governed by our own sentiment of the time, because we are a new different Congress from the 16th Congress. That is just my point of order, Mr. Chairman.
We now recognize Congressman Marcoleta. Dami pa, 1, 2, 3.
Thank you very much, Mr. Chairman. I too wish to apply the essence of liberality, but hearing from our distinguished colleague, the complainant himself, answering from the intense questioning of our majority leader, when he categorically admitted that he has no personal knowledge to all those facts that he mentioned in his complaint, and his concept of personal knowledge actually was allegedly based on the called authentic documents. But I believe, Mr. Chairman, he being not a lawyer, we cannot blame him for that, but it seems to me that his concept of personal knowledge is the very concept of hearsay. Because all of these facts enumerated in the complaints, as you can browse it from the complaint itself, were all taken from articles online, sourced from the website. And so in the authentication of this, Your Honor, we will even apply the rules on electronic evidence. And there is precisely a strict system on how you even authenticate electronic evidence. That has not been accomplished, Mr. Chairman. So if we're going to proceed, despite the fact that the verification section is very critical here, paragraph 3 says that the complainant must at least have personal knowledge. And he admitted that he has not. I don't think, Mr. Chair, that we can set aside the technicality. Because by doing that, we will be impairing the very essence of jurisdiction. We cannot set aside the technicality. And I'm very sorry that I have to disagree with some of my colleagues here and friends, particularly Honorable Edsa Lagman, who in the organizational transition of this Congress has been part of my life being in their group. But considering further that this is a very important political process that we have to determine and dispose properly, I cannot find the justification to continue because the admission itself is very strong that the complaint does not rest on personal knowledge. Thank you very much, Mr. Chair.
Thank you. We now recognize Congressman Tugna.
Thank you, Mr. Chair. Good morning to the members of the Justice Committee. I understand, Mr. Chair, that the discussion has been about whether this committee will apply liberality or strict application as to the form of the impeachment complaint. Mr. Chair, it is the position of this representation that the current impeachment complaint as to its form is very much related as to its substance, which we will be subsequently discussing if in case the committee will uphold the motion to the earlier withdrawn motion to vote on the form of the complaint. This representation believes that since there is absence of personal knowledge, in law school I understand personal knowledge as that to have personal knowledge, the complainant must have in his own senses, he must have perceived what he is complaining of. It may be in the form of the sense of sight, sense of smell, sense of hearing, and the two other forms of senses. But in this particular case, it is about whether or not you have seen the actual matters that we are discussing here. So, Mr. Chair, the position of this representation is that the vote on the issue of the form will necessarily be intertwined with the substance that will be voted upon if in case the committee will vote on the issue of form later. And also, Mr. Chair, this representation also manifests that while impeachment proceedings is a measure of check and balance as to the impeachable officials in our country, we have other forms of check and balance as to the allegations here contained in this impeachment complaint. I believe personally that an impeachment complaint is divisive and it is time-consuming, considering that there are matters of legislation that the 17th Congress has to tackle also. And also, as to the check and balance mechanism on our impeachable officials, it is very important, and there is the presence of a vigilant media and a vigilant citizenry to have a check and balance as to our impeachable officers, and that includes the President. I manifest, Mr. Chairman.
Speaker, Mr.
Thank you
Chairman.
for that.
Mr. Chairman, everybody's
Congressman
explaining their votes already. Can we go back to the previous question and then let's just vote and let them explain their vote after?
Mr. Chairman.
Mr. Speaker.
We will just give Deputy Majority Leader Bondok another chance, and Deputy Speaker, sino ba? Si Congressman Garbin and Garcia and Gonzaga. After that, we will end Akop. You know, napaka-importante po kasi nitong issue na ito, no? That the chair felt that it is imperative that we hear out as many members of the committee as we could, no? Kasi kanina mukhang simple lang, pero yung objection ni Deputy Speaker Castro na talagang emphatic, talagang passionate, parang maraming nadala. And so this is why we would like to hear out our members, no, to give them chance. So we now recognize Congressman Deputy Majority Leader Bondo.
Good afternoon, Mr. Chairman. The rules of the House have been often invoked in this proceeding. The chairman of the powerful Committee on Rules, the esteemed bar top notcher, the Honorable Rodolfo Castro Fariñas, is present. And he was our previous chairman of the Rules Rewriting Committee. My name was mentioned by an esteemed colleague, the Honorable Sandoval, as having been present in the Committee on Rules for 4 terms now, and a member of the Committee on Justice as a full member or ex officio, having undergone numerous impeachment proceedings. And now, through the wisdom of my chairman, the Honorable Fariñas, it is this representation who is the chairman of the Rules Rewriting Committee. It is the opinion of this representation that we can rest assured that we can already dismiss this complaint on insufficiency of form, should this committee so wish. It was postulated earlier that it would have to be at the point of insufficiency in substance, but rest assured, the wisdom of the committee will be accepted and still be voted on by plenary. So it is the interpretation of this representation and will be reflected, should you so wish, in the future rules of the House, that we can already dismiss this complaint should we find it insufficient in form. Thank you, Mr. Chairman.
Thank you, Deputy Majority Leader. We now recognize Deputy Speaker Garcia. Sorry. Before that, si Deputy Speaker Abueg. Ang layo mo kasi dyan.
Yes, Mr. Chairman. Thank you, Mr. Chairman. If I may, well, I don't know if this is explaining the vote already, Mr. Chairman, but I had a chance as presiding officer to refer the complaint to the Committee on Justice, together with the majority with Congressman Gulyas. I also had the chance for how many days to consult with my constituents. I just want to present this to the committee, Mr. Chairman. Gustong ipaabot po na aking mga kababayan sa 2nd District ng Palawan na suportado pa rin po nila si President Duterte, whether or not form of the complaint is sufficient or not. Thank you, Mr. Chairman.
Thank you, Deputy Speaker Abueg. And we now recognize Deputy Speaker Garcia. Please, your turn. You're recognized, Deputy Speaker.
Thank you very much, Mr. Chair. I wholeheartedly agree with the majority of my colleagues that an impeachment proceeding is divisive. It holds us back. And I, more than ever, would wish to see these impeachment proceedings closed. But I believe that the question that has been lingering on my mind as regards our own rules, Rule 3, Section 4, vis-a-vis and in relation to Rule 14, was previously categorically answered by our good senior deputy majority leader. Because if we were to review Section 4, Mr. Chair, which is determination of sufficiency in form and substance, the first paragraph, which refers to insufficiency of form, is rather ambiguous as to whether or not such a complaint may be dismissed. If I may read, if the committee finds the complaint is insufficient in form, it shall return the same to the Secretary General within 3 session days with a written explanation of the insufficiency. The Secretary General shall return the same to the complainants together with the committee's written explanation within 3 session days from receipt of the committee resolution finding the complaint insufficient in form. Now, the second paragraph refers to the finding of the committee of that complaint as insufficient in substance. And if I may read, should the committee find the complaint sufficient in form, it shall then determine if the complaint is sufficient in substance. The requirement of substance is met if there is a recital of facts constituting the offense charged and determinative of the jurisdiction of the committee. If the committee finds the complaint is not sufficient in substance, it shall dismiss the complaint and shall submit its report as provided hereunder. If you would notice, Mr. Chair, there is no such statement of dismissal of the complaint in the first paragraph, which refers to insufficiency in form. Now, I had a little hesitance there because then, as pointed out by former Justice of the Court of Appeals, Congressman Veloso, we do have Section 14, which is scope of bar, which states that no impeachment proceeding shall be initiated against the same official more than once within a period of 1 year. This would then be the reason why, as I had earlier stated, I am not for impeachment proceedings. It holds us back from what should really be our job, and that is legislation. Now, if indeed our rule under Section 4 is rather ambiguous as regards insufficiency of form, would that not then, as earlier pointed out by Congressman Veloso, give cause for another complaint to be filed within the same year. A corrected complaint that may be filed, because in fact, there is no such definitive statement under the first paragraph as regards insufficiency of form. If we could get a very clear statement now from the chair, then I believe the members will know where to go. Thank you, Mr. Chair.
Mr. Chair?
Just to respond to that, as you were saying, there is nothing in the rules that will say what will happen to a complaint once it is dismissed in form.
Well, it states
Or
that
rather, once
there is a process, Mr.
we
Chair.
vote on insufficiency in form. Walang rule, ano? And I guess for this chair, as I said, I cannot even vote unless to break a tie. This is all the decision of the majority of the members of the Justice Committee and ex officio members. So whatever will be that decision will stay. And mind you, the rules of the House, by reason or by virtue of the separation of powers, cannot be looked into by the Supreme Court. So this is a constitutional mandate that I have time and again said beyond the ambit of judicial review, and therefore I guess if the body will decide in favor of dismissing, even without any provision in the rules itself, then that will stay. That is the mind of the chair on this particular point, just to answer directly the point of Deputy Speaker Gwen.
And just to further clarify it, Mr. Chair, if with the indulgence of the Vice Chair, so that if that will stay, then also it goes without saying that no other impeachment complaint shall be entertained within a period of 1 year, as in compliance with Section 14.
If that will be the decision of the body, then we will incorporate that in the report for clarity of the decision and or resolution that we will submit to the body for approval.
Mr. Chair,
Mr. Chairman.
as movement of the...
Mr. Chairman.
Is that to clarify this point?
Yes, Mr. Chairman.
What about yung ano? Is that also
Yes, it needs
related?
correction on that, and I will have a succeeding motion
So,
insofar as... Yeah,
so we will...
I will yield to the Senior Deputy
sige,
Majority Leader.
Deputy Majority Leader.
Thank you to our esteemed colleague, Honorable Waminal, and to our Honorable Chairman. This is why sufficiency in form and sufficiency in substance are decoupled. They are separate, decoupled. They are separate discussions. And while the rules are not perfect, it states here that it shall be returned to the Secretary General, and to my mind, this should include that it is considered dismissed. And if this is the wisdom of the committee, rest assured that the Committee on Rules will incorporate it in future rules on impeachment proceedings. But nothing prevents us from dismissing it now, whereupon Section 11 of Rules of Procedure in impeachment proceedings comes into play. When the report on the Committee on Justice dismisses the complaint, it shall submit to the House a resolution for the dismissal of the verified complaint and or resolution of impeachment. A vote of at least 1/3 of all members of the House shall be necessary to override such resolution. Meaning, our decision in the Committee on Justice shall still pass the judgment of plenary, sustaining our wisdom or overriding it. Therefore, we are well within our rights, sitting in quorum here in the Committee on Justice, to dismiss this due to lack of sufficiency in form, Mr. Chairman.
Thank you for that. Deputy Majority Leader. We still have, we will entertain two more remarks, that of Congressman Gonzaga and Acop, and thereafter, but before that, we will recognize first Deputy or Vice Chairman Umanal. Just on this point.
Mr. Chair, I yield to the two gentlemen who had registered for them to be recognized before I'll make my subsidiary motion, Mr. Chair.
Okay, so this is on the motion, on subsidiary motion. So we now recognize Congressman Gonzaga and Acop.
Thank you, Mr. Chair. First, I will discuss the issue raised by Honorable Gwen Garcia with regard to the vagueness of Section 14, Rule 3 of the impeachment proceeding. The issue here is whether or not there would be dismissal if there is a defect in form. I should say there is dismissal. Why? First paragraph of Section 4 says that if the complaint is insufficient in form, it shall return the same to the Secretary General, period. Now, there is that what we call gray area. But if we harmonize this first paragraph with the second paragraph says, should the committee find the complaint sufficient in form, it shall then determine the complaint is sufficient in substance. So that is a positive language put into a sentence. But what if there is a finding of the committee, there is insufficiency in form? Therefore, we will not go anymore to paragraph 2 of Section 4. If there is insufficiency in form, therefore, this committee will not go into the discussions as to the sufficiency in substance. Therefore, that is tantamount to a dismissal. So, with regard to whether or not the petition or complaint of Congressman Alejano is properly verified, I should say it is not properly verified and subject to immediate dismissal. What are the laws available here? The Constitution says, Section 3 of Article 11 says, a verified complaint for impeachment may be filed by any member of the House, as in this case. So, is there a proper verification? The answer is, there is no proper verification. Upon the inquiry upon the questions made by the Honorable Majority Floor Leader, it says, Congressman Alejano has no personal knowledge as to any allegations in his petition. So if we go by then we go to the second rule. The second rule is the rule on impeachment. This what we have adopted. So what is the rule on impeachment? We have to go on Section 4, Section 14, Rule 3, or Section 4, Rule 3 of the impeachment. So what is that? We have to determine, the Committee on Justice will determine whether or not this petition is insufficient in form or sufficient in form. So what are we going to discuss? Verification stage. Therefore, the questions of Majority Floor Leader is clear or are clear. Therefore, there is no verification as to the requirements set forth by law. So, if we're going to apply the supplementary laws available in our land, we have to discuss Rule 130 of the Rules on Evidence. What is that? That is the rule on personal knowledge and the rule on hearsay. The answer of Congressman Alejano justifies all the allegations are considered hearsay. Therefore, Mr. Chair, it is my opinion that the complaint of Congressman Alejano did not pass as to sufficiency in form. Thank you, Mr. Chair.
Thank you for those remarks. We take note of that. Now, we recognize Congressman Acop.
Thank you, Mr. Chair. Magandang hapon po sa atin lahat. This is the first meeting of the Committee on Justice, which I have attended simply because I was just made a member of this committee last week. Reading Rule 3 of Section 4 of our rules on impeachment, there are no parameters insofar as this section is concerned. And therefore, if there are no parameters given, then we have to rely on other sources of rules, like the rules on criminal procedure, in order to find out whether a verification is proper in form. Tama po. So, applying the rules on criminal procedure as far as I know, a pleading or a complaint which does not have the proper verification is supposed to be an unsigned pleading and therefore should be dismissed pursuant to our legal principles. So that is the point insofar as verification is concerned. Now there is an issue which I would like to take up. Number one, what we are going to do today would establish a precedent which shall be followed or observed by the succeeding Committee on Justice. And the other one is, as mentioned by the Honorable Lagman, the issue on right to be heard. These are two competing legal issues insofar as this representation is concerned. Now, which would take precedence? The right to be heard, or we dismiss the complaint because of improper verification? Now, if we follow the legal principle, the pleading is unsigned, but it is arrayed against the right to be heard. So, as far as this representation is concerned, these are the two competing legal issues in my mind. Magandang hapon po sa atin lahat.
Maraming salamat, Congressman Acop. You know, I would already go for the motion of Congress. I would like to hear the motion or supplemental motion of Congressman Uminal, but we will not do justice to the complainant himself if we do not hear him. So, as a last and final manifestation, may we hear from you, Congressman Alejano.
Thank you, Mr. Chairman. Kahit paano makapagsalita po tayo. I respect the opinions of my colleagues here in the committee and in the Congress. I understand I am not a lawyer. Yes, I accept that. I just would like to clarify again that the issue of verification, specifically on the issue of personal knowledge, I would like to emphasize again that those are my personal knowledge as I went through the documents that I have examined, the things that I've heard, and personally, I've heard the policy pronouncements of the President on the issue of policy of killings, espousing the policy of killings, and I have taken the pains of verifying the policy pronouncements of the President from Malacanang as to the pronouncements of the President. Narinig po natin lahat. Actually, those are public knowledge sa lahat. Narinig po natin even the policy pronouncements of the President on the issue of our rights in West Philippine Sea, in Benham Rice. Narinig po natin yon. Kaya nga sinasabi ko, public knowledge po yon. Ngayon po, dito pa lang ho tayo sa issue ng form at may requirements, although hindi ganon kaliwanag, may requirements sa issue ng form na dapat siya ay na-file, na i-endorse ng members of the committee at na-refer. Ngayon po, parang pagkakaintindi ko po, isa format pa lang tayo tumitingin. And kanina po, we went through the discussion of the substance. Actually po, sa pagkakaintindi ko rin, And the issue of substance is just a recital of ultimate facts. I-recite lang mo doon. The determination whether these are true or not that will influence the members of this committee, whether there is a probable cause or not to the complaint, doon pa yun papunta after the determination of the substance. But again po, I was not given that opportunity to really explain my point kung bakit it complies with the requirement of form. And later, when we conduct our voting for the issue of form, and in the substance, sana mamaliwanag yung basis bago to tayo pumunta doon sa pagbubutuhan. I agree with the rules. I understand, as mentioned by Representative Rimpi Mondok, tatlong hiwa-hiwalay po na proseso. In every stage ay merong independent action ang members of the committee or the committee itself. Ang sa akin lang po, on the issue of personal knowledge, yes, hindi ako witness ng pagbaril ng mga biktima ng war on drugs. Hindi po ako witness. I am a witness to the affidavits, to the testimonies, and lahat po tayo nakarinig. Siguro po, hindi naman tayo na sa ibang bansa. Alam mo natin na may patayan ngayon sa lansangan. Yun lang yung puntuhan natin, that this body, I appreciate that we went through the process, we were given the chance to went through the process. Yun lang yung pagbavalidate kung tama o hindi, doon po sana doon sa issue ng pagsasubmit po ng mga dokumento, pagsasubmit ng mga testimonya, evidentiary documents, para makita kung totoo o hindi. So far, forma lang, and then later on, pag-recite lang kung ano ba yung gusto mo mangyari pag-recite. And later on, that will be proven by the actions of this committee. So once again, Mr. Chairman, thank you for this opportunity, even if I am not a member of this committee.
Thank you for that. So now we recognize Congressman Uwaminal, Vice Chair.
Thank you very much, Mr. Chair. It is the position of this humble representation that impeachment shall not be resulted to harass hard-working and dedicated public officers like President Duterte. However, it was my reservation because of Section 4 under Rule 3, which was well explained by my co-chair Biluso and Deputy Speaker Gwen Garcia, but with the explanation of the Deputy Majority Leader, the Honorable Rimpi, and that the clarification made by the Chair that the one-year bar rule will apply if the committee desires to declare the complaint as insufficient in form. So with this, Mr. Chair, I move to suspend the proceedings to allow the members of the committee to rethink, to assess our individual position on the matter, and resume upon the call of the chairman of the committee.
The motion, it has been moved and seconded.
What happened
Any
to
objection?
Mr. Chairman, what happened to the previous motion?
Kanya nga, we will suspend the hearing because the chair will ask the members of the Justice Committee for an executive session because we have heard the different positions of all members, and we would like to discuss this in executive session so that you know, we will have a second chance to look into the aspect of the ambiguity in the rule so that we can be clear on how we will dispose of this particular issue. Anyway, this proceeding is hereby suspended, and the members of this is suspended for a few minutes, and we will ask the members only of the Justice Committee for an executive session so that we can further discuss this, and then we will resume after we have arrived at a decision on our way forward on this particular proceeding. So session is deemed suspended.
Where's the venue?
That's the House.
Yung mga members only, no? Can we
let's listen in first again.
Executive session.
All right, that's the House Justice Committee Chairman, Congressman Rey Umali, suspending today's hearing. They are going to go on an executive session to discuss further and to give this the rules on the impeachment complaint a second chance. He calls it to look into the ambiguity of the rules in order to dispose or have some sort of conclusion in the impeachment complaint filed by Magdalo Representative Gary Alejano. What we heard the whole morning was different reactions, or were different reactions and statements coming from members of the House Justice Committee. Also towards the end was Congressman Gary Alejano. He was given a chance to explain his impeachment complaint. This really centered around in the beginning whether the complainant, Congressman Alejano, had personal knowledge of what he stated in his impeachment complaint, specifically those attributing to the thousands of deaths supposedly perpetrated because of the war on drugs, a number of, back and forth from the majority leader, Congressman Rudy Fariñas, and Congressman Gary Alejano on whether he does have personal knowledge. To the end, Congressman Alejano says he does not have personal knowledge, but he did clear out and explain that his personal knowledge is really based on research, based on pronouncements made by the President, and also he admitted that he was not a witness to actual killings. Really, it's more centered on the witnesses and their affidavit. So again, this should really look into the sufficiency in form first and the sufficiency in substance rather of the impeachment complaint, again filed by Congressman Gary Alejano. They are going to go on executive session, and after that we can expect the resumption of the hearing. On your screen right now, the congressman who filed the impeachment complaint being interviewed by members of the media. Good to find out if this is exactly what he expected, or if you or I expected a vote to happen today. Again, it's a vote supposedly on the on two things, rather, on the impeachment complaint filed by Congressman